is whether they're a preliminary note and whether they're kept in the ordinary course and scope of business. And then the second view, if they are preliminary notes and if they have been kept, then you have to look at the public interest in disclosure. So we're going to have a training on that in February, hopefully. Orange County had a great transitory record policy, which, and then they were sued and then they withdrew it. But so it's an evolving topic throughout the state about specifically regarding emails.
And just from a process point of view, going through or creating policy, that's what you do, may take time, may take 6 months, may even be longer. So, you have to have those notes. You should have notes and be able to reference it because it may take a lot of time to process them.
None of this is to chill the way you do business as a supervisor. It's just to give you a heads up that we don't want you to come back in a year or call Ray or Barbara and say, but you didn't tell me that, I might have to turn over my notes if they're permanent or something. It's just more to give you a framework in which to work in, not to change your pattern in practice. That said, let's talk about social media. Hot topic: text, blogs, Twitter, Facebook, Instagram. Huge change. The legislature finally, last session, effective this year, this January 1st, codified what you can and can't do as a local official with your social media and the Brown Act. And this is huge for a lot of you because you are linked on a variety of social media. We're gonna, Joel kind of previewed it, and you've heard a little bit about fair process and due process. We're gonna get to it much more in depth, but here's another preview. The new legislation says you as a local elected official or an appointed official, it's going to hold true for your planning commission or any of your boards or commissions, you may not directly respond or react to a post or shares concerning your local agency business posted by another person of the same legislative body. So if Supervisor Medina and Supervisor Tiffany and Supervisor Kosmicki and Supervisor Gonzalez and all of you are friends on Facebook, or you are all on LinkedIn together, which also has a thumbs up or a like or whatever. The new law says you may not respond or react. So that's emojis, that's a like, it's not even a comment if it's from somebody else on your board or commission. That doesn't mean to say that if somebody gets a new position outside of the, or they have some success in their personal life or their professional life, that you can't like it. And you can certainly congratulate each other that you've got some new achievement in your personal or professional life. But if it is regarding county business, then you are heavily restricted now under this new legislation. We don't have any case law yet. We don't know how it's going to play out. But now the legislature for the state is looking at the Brown Act with technology and starting to bring it forward into the current century and addressing some of these issues. You're going to be hearing a lot more about this as the year unfolds. But let's talk about what you may do. You can answer questions from the public. If you've got some sort of a blog or any kind of social media and somebody asks you, is the board thinking about this? Yes, that matter may come up. It's coming up at the next meeting. It may be coming up at a future meeting. But, where do I find out information? You certainly can answer a question from the public. You can provide information that's equally available to the public. Upcoming hearings, meetings, information that's already posted on the county website. You can also, as a supervisor, because your role, like Ray said, is to talk to people, find out what your constituents think. You can solicit information from the public. So you could use social media to find out what your constituents are thinking. Of course, Problem is, you don't know who's going to be responding and whether they're your constituents or not necessarily. You may or may not know everybody in your district, so, but you can do that. So there's a lot of things that you can do on social media, even under this new legislation. But again, it is more restrictive. We certainly thought that that was the way the courts were going to trend and the legislature was going to trend, but this is very clear this year. So watch out about social media and how you use it in your role as a supervisor. Questions, comments? I mean, we can go through.
I have a comment about the new, the AB 992. Mark, thank you, over the last year has been posting information, posting information on the numbers, the COVID numbers, the positive test results, when someone passes and so forth, and it's a great informational tool. But I would frequently, prior to 1/1/21, is I would comment on that, something. And now I feel like I'm being muffled here and I can't even, and muzzled, that I can't even respond because that issue is coming up on Tuesday. And so, and I don't want to take that away from you, but can we somehow get that dashboard to be coming directly from David, our PIO, so that way it's not coming from someone from this legislative body and there's that potential to chime in. And I appreciate what you've been doing, and it's very informative to the public. Comments have been positive and negative in terms of the information shared. Somebody's phone is buzzing like crazy. And so I just want to be able to. I personally have chose not to make any comments on Facebook since hearing of this, and especially since it went into effect and we're sworn in on the 4th of this month. But it's just been kind of, it's hard to wrestle with this. So I've shared this with other people in other jurisdictions who are having similar issues. But I just would like to be able to put something on Facebook. I understand about sharing the information, gathering information, soliciting information from the public, but I'm kind of concerned.
So, if I may, so I do know that David does message out through Nixle. I do know that there is a social media presence. I will verify and make sure that is happening. I thought that is happening. I'm pretty sure that's happening. I see that almost every week.
It's happening, but it's, the way I look at it is, with Facebook, with any social media, we as elected officials, we can post what we want.
Right.
The question at hand is, you just can't respond.
Right.
That's so that, whether it's David or anyone posting on it,
Yeah.
you just can't respond. So it's the same, it's the same outlook.
Well, it's
Yeah, I think
actually
that didn't
not.
answer the question. Like, basically, you could cut and paste that
And share
post.
equally.
You could
yes.
share it yourself,
And
you
I
could
have-
share
and
it
I have
yourself.
done that, yes.
and that's-
You just can't respond to another post.
I mean, even a simple emoji of a sad face when we had 5 deaths, I'm like, oh my God, did I violate the procedure? Because I know that conversation is going to come up on Tuesday, and
But even if Dave was to post it, you still can't do that.
Well, if he's not,
It doesn't make sense.
if he's not
he's
part of
not-
your
he's not part of the
legislative
board.
body,
Well,
So-
but
Then-
if she posts something,
Yeah, then-
then no one else can post after that.
Right.
No,
That's what I'm referring to, right?
so you could post.
Not after she posts.
Not
though.
after she posts, because
Don't
then
let
you
one
have two
person-
on the
people.
same
That's,
post.
that's what
On
I'm
your-
saying.
Right,
Yeah.
on your
Yeah.
Facebook or your social media, your Instagram, whatever blog you're using, you could post the same thing. Certainly, if county staff is preparing it, you all could post it. You just can't do the sad face, I mean,
Yeah.
and again, it's not a judgment, and it's gonna be different because
oh,
that
I
is.
understand the ramifications. Yes,
Yeah,
I
it's
understand.
just, the way that this law is evolving is that the idea behind it, if you look at the legislative intent, is that you're not forming a consensus, outside of a public meeting. That's just debatable, but, that's the genesis of this. And you can see where, you could, by liking, disliking, commenting, might actually inadvertently do that. But again, you could still post, and if the county's posting it, you could actually respond to a county post, because the only restriction is that you can't respond to somebody else that sits on your own legislative body.
But then only one person could respond. So the first person that
serial meeting.
responds would get dibs on the response because nobody else could respond to that same post.
I think the safest thing, in my opinion, is, and I did this last night, I think, when you had posted something, just let's make a pact here that we're not going to we're not going to comment on any of our individual posts. I'm sorry, maybe I'm oversimplifying it.
No,
But
no.
it's completely simple.
I agree with you.
So-
It is a balancing act because,
It's first come, first serve, right?
with social media
Yeah.
nowadays, that's how so many people get their information. And, to what was discussed earlier, I think we may need to look more at where Dave is putting out information.
Yeah.
I mean, there are, certain popular social media sites, Facebook pages within our county that, we may want to look at, that's where he's posting stuff. And I was thinking about, for example, the vaccinations, and
Yeah.
the tier and all that. But it is slippery slope because, you're out there. I mean, some of the Facebook pages in themselves, depending if you're a member of that or not, you are somewhat tipping your hand as to what your political feelings are about certain things. I can think of several that are, one's very conservative, one's more liberal, that kind of a thing. I don't know if that's a risk. But what happens is you get on social media and then people, naturally, they comment or they want to give their opinion and they're expecting you to respond. You can't really respond. So anyway, it's
Yeah, and
difficult.
so I hear all of you. What I'm going to do is I'm going to make sure that this item's on our agenda Tuesday during COVID, just to talk. Where's the information at? And that's something we'll make sure you
And
understand in the public.
the last thing is if a supervisor's tagged on a post, what are we to do? Just ignore it?
Basically.
I
Right.
think you can't
Yeah, that's,
respond.
what I'm referring
Like
to.
if all of you were tagged.
Well, a lot
on
of
this
this, yeah, a
thing.
lot of that happens is, you'll get a Facebook post. Go ahead, Robert, you can answer my.
I just want to, is this thing on? A lot of times, and especially hot button issues, members of the board are tagged. Can one of them just say, due to a new law, we cannot comment and just leave it at that? Because you don't want to just not respond.
Yeah,
because
that's-
then
thank you.
Members of the public
Yes, they're
will
mad.
say, you're ignoring us. So I think somebody has to step up and say, due to whatever the new law, AB 992, we cannot respond and just leave it at that.
But couldn't one person respond? Like,
But
if
who
somebody,
wants-
if you wanted to.
But who wants to respond?
Well, the challenge though, theoretically,
Yeah.
I mean,
Chair, maybe the chair, we can somehow talk about it and say maybe the chair should just do what Robert said. I don't know, I'm
The
just.
official
Yeah,
speaker
I'm
of
just-
the
Yeah.
board, yes, I
I mean,
agree.
if there, I guess, yeah.
yeah.
It depends on whether somebody that you know is personally tagging you or whether they're tagging the whole board.
They usually tag the whole board.
Yes.
It's all.
And again, nothing in this, so for the COVID situation, if there's information available to the public, to all of you, you can certainly share that with your constituents. You can post it on your site as well. If you're all in the future at a ceremonial, a ribbon cutting for something or some new, you could share a picture of that. You just can't all like that thing, the same
Right.
thing, kind of.
But I do think that, as you were saying, Ray, we need to look at what needs to get out there. Certainly with the COVID information, it would be easier if all of us up here knew that on all these key sites, that information is getting out there. So that, I don't have to wonder, should I be posting this, or is Colin going to take care of that, or is Mark going to, or B, what I mean? So I think we should be, if we knew that it's going to be taken care of by Dave, then we don't have to worry about getting it out there.
Yeah, no, I appreciate that, and I completely concur and agree. We have presented, all the websites and everything before, but I think it's a great reminder. We have a new board. I think it's important that you know where to be able to pass that information to your constituents. I think it's important. We'll just go back again, and we'll do it regularly. I think it's important because that's one thing that this board or the board had requested, is to make sure that we communicate. And so I'll make sure that our PIO, David Westrick, presents and informs you of what's happening and on the communication side of things.
But to be clear, we can share our views on local issues on social media, correct? I mean, there's a presumption that others on the board are going to see those views. Otherwise, we're definitely being muzzled.
Yeah,
you know.
no, yeah, you can share, we just can't comment.
As long as you don't comment.
Yeah, as long as
Right.
the rest of
Got
us
it,
don't
yeah.
comment.
And then Supervisor Kozmicki, we're going to talk a little bit more in the land use context about where that line is, about when you've stepped over, or where that line is so that you don't step over and you can still participate. And it's still a fair process, fair hearing and things like that. So yes, but today, I think unfortunately, you're going to hear that from a lot of us, is that, these are guidelines and rules and regulations, and how they're applied devil's in the detail, of course. Okay. Again, what's not a meeting? We've talked about this, kind of beat a dead horse, that individual conversations or contacts between less than a majority are not a meeting. You can call a colleague and have a discussion. It's just might be risky if there's a third member that's involved in that. But as long as you know where that line is and where you can draw it and not cross it is what the goal is today. Okay. Not a meeting. You can attend public gatherings or conferences. You can go to classes together. You can go to ceremonial social functions. You can, meet up in the coffee shop in the community downtown. Although, interesting enough, City of San Francisco, there was a majority of the Board of Supervisors that was seen lunching at a San Francisco restaurant last year. And wouldn't you know that was front page on the Chronicle newspaper the next day, because there was a presumption that they were violating the Brown Act. Nobody knows for sure. They were, requested to share their, what they were meeting about. But there's always that appearance of impropriety that you have to be careful about too. What's not a meeting? And you can go to open notice meetings of another body, of a local agency. I'll defer to Ray if you have a local policy about that. It can be intimidating if all of you were to show up at the Planning Commission on the same night, and that's usually not recommended. But I've worked in a lot of jurisdictions where planning commissioners sit at board of, supervisor meetings, and one or two board of supervisors go to planning commission meetings, because you want to hear. Now with everything online, it's easier to just do it remotely and things like that. But there's nothing to prevent you from attending. We'll get into a little bit about whether you can participate and the risks on that as well. Okay, questions before we move on this?
Maybe you're going to get into this, but something I've been involved in is the San Benito County Business Council, for example, and we would invite members of the city council as well as members of the
right.
board of supervisors. Now, we generally were careful to just invite 2 at a time, but on occasion, we'd have, 3, let's say, supervisors show up. Are you, if they're just sitting there listening, there's probably not a problem. But if we call on a supervisor to make a comment about a particular issue, is there a problem because there's 3 of them there?
So again, it's the scope, and you're right, for social events, for a business council, Rotary, any of those kinds of, you can all be there if one of them is speaking, and doesn't mean that the other ones can't be there. But you couldn't have a quorum doing a panel at one of those meetings without
If
it.
multiple supervisors are making comment on an issue, because by definition, the business council, we talk about county issues. So it's
So
not
if
just,
there's
it's not
more-
just
if
strictly
there's-
social.
If there's quorum, and there's more than, the quorum there's 3 of you, and you are talking about matters that are county business that are going to be under your consideration, then likely that will be construed as overstepping the line.
Shouldn't be doing that.
Because the public's not invited, they're not all there, they're not hearing what you say and things like that. There is a way to have a forum. I mean, League of Women Voters and other organizations do that, and it's open to the public.
Yeah, and I was just going to add, I'm going to be discussing a lot of what do we do for our meetings, commissions, board meetings. So I'm going to have that part a little later. But with this, when it comes to the business council, there's usually just 2 board members. There are at times, if 3 have been invited, one of the board members will say, oh, no, I'm out.
Yep.
And that's just the way it is. So that's a good rule of thumb for all of you. If for some reason you get invited or whatever, just make sure that there's no more than 2. That's basically it. And, normally I work with the business council. There's agenda items. We're going to invite an RMA director. We're going to invite the CAL, talk about county business, or the board member, maybe a board member is invited. It has something that deals with his district. So those are the things that kind of come up. But just a rule of thumb, no more than 2. If you see more than 2, then just go ahead and leave.
Right.
Yeah.
Okay. Thank you.
Okay. What's not a meeting? Again, it's not that you can't be together, it's that you can't discuss county business among yourselves. It can't be part of a scheduled program, outside of a noticed meeting, noticed under the Brown Act in the county. Okay. Where can you hold a meeting? Well, that's a little new now. General rule is you have to meet within the boundaries of your jurisdiction. There are some limited, narrow exceptions. If there is, for some reason, you want to go visit a project site or something that you're doing outside of the county, but generally, you're restricted to meet within your jurisdictional boundaries. Meetings and documents must be accessible to all. And so we talked about that. So when an agenda is posted and all of the supporting staff reports, all of the documents, has to be accessible now online, has to be available at the county offices. It has to be made accessible to the disabled. Can be no restrictions on admittance to these open meetings, with the exception of the governor's order. No entrance fees, and documents have to be placed in alternative locations. They're usually placed in a library or some other public locations. And to your benefit, the staff just does that seamlessly. You don't even have to worry that that's being done. It just happens like magic.
So real quick on that, I was actually going to highlight that for the certificate of posting as an example. So I'd like to ask, or maybe ask of you, do you know where those postings are for our county?
I do. only
Supervisor
two
Gonzalez?
locations. The old courthouse and then here, but my question was, why can't there be other locations? Because not many people are mobile, but I don't know where the other location might be.
Yeah, and it's online. We have it online. So that, yes, you are correct. Those are the 2 locations we have. I wanted to make sure that was available and aware to you and the public. It doesn't mean that we can't put it in more locations. We could do that, and we can discuss that at a later date. I do want to mention, and I'm going to probably highlight this depending on timing, that there's a lot of these things that I'd like to come back during the board retreat and actually discuss, the actual board's roles and responsibilities. Some of these nuances, I think these are really good topics to talk about and delve into a little bit more. But I think, there's so much content. We're only in slide, I don't know which one we're on now, but we still got a lot to go. So, but yes, I think we can, and I think it's good for a discussion item later, so.
We're
with
about
that.
a third of the way through. If somebody needs to stand up, stretch, I know we're just kind of racing through this, so just let me know. Okay. Teleconference by telephone, video, your quorum has to be located within the agency's jurisdiction, even if you're off-site. And that comes up in the normal course, not under the current rules, but somebody's on vacation and it's an important meeting or an important item and you want to participate, work with staff. There's all sorts of rules under the Brown Act about how to notify where you are and participate by teleconference. Interesting, under the current Brown Act rules, not the new order by the governor, you have to identify each teleconference location. So if you're in Hawaii on vacation, you actually have to post it on your hotel room or in the hotel, or you're at somewhere else, and the public has to be able to access it. It can't be on behind a private locked gate. So there's all sorts of reasons you will or won't going forward when meetings aren't always online, that you may or may not want to do the teleconference option if you're outside of the jurisdiction, and just work with staff on that. But there are specific rules that if you're not going to physically be present within the jurisdiction, how to participate. One of the things that's both in the current as well as, the emergency rules is for all teleconference meetings, anybody participating by phone or video, roll call votes have to be taken. That's a little nuance that's come up. Current teleconference rules, and that goes back to the order by the governor's office. It allows agencies to participate in meetings by teleconference. You just have to have one location. It's usually your, main location, your county offices, where there's actually a physical location. Everybody else can be accessible by teleconference. The public has to not only be able to access it, but to be able to participate. They have to be able to have, as staff said, their public comment period. And there has to be all sorts of identification on how to access the agenda and the materials if you're not in a physical location. Yes.
In the new governor's orders, and this has been, some disinformation that is flying around, wanted to make sure that you can validate this, or I should say correct it, is that person that is participating via Zoom their picture must be shown, and they must be, I believe what I read was that's false. I just wanted to make sure that I'm correct.
Yeah, there is no requirement that the video, because you can participate by phone. There's
Yes.
no obligation that you actually turn on your camera or even have a camera. Again, it's that a lot of people, I mean, even if you can't believe it, I mean, plenty of old computers don't have video capability, and you don't want to, in any way, not be inclusive. So that's why phones allowed for that. So no mandatory video. So thank you for clarifying
That's
that.
all I needed to know. Thank
That's
you.
correct. And truly, a lot of people would be chilled by a requirement that they had to show up in video these days.
Oh, I'm speaking
So-
of just elected officials, not
Oh,
the
okay.
constituents.
Oh, I thought
I'm
you
talking
meant
about,
the
no, I'm talking
public.
about an elected official, when they're participating via Zoom, do they have to show that, they're there and they're,
So it's certainly going to be preferred because your constituents want to know that you're there and that you're paying attention. And the concern has been, and I just comment that anecdotally, if you're distracted and you're doing something else, then there can be an issue about whether it's a fair process,
But-
due process.
yeah, but that is,
But-
once again, that's all,
Different.
that's different. I'm talking about
Right.
legally, is it written in the ordinance
I
or the
haven't
executive order?
I haven't seen that in the
That's-
executive order mandating that
haven't
you're.
seen
I haven't seen it either, but I'm just
Yeah.
hearing things around here, and
Okay.
I want to just, could you possibly
We'll verify
check
that.
on that? And that way, maybe on Tuesday, I can give a little bit of a update saying exactly what we're talking about.
Because you have two questions here. You have one as to the public calling in.
Well, the public, I
Yeah,
know,
not required to video,
the
and
public
that's
I
not an
knew
issue.
already.
Right.
I'm referring just to the elected
Those of us on
officials.
this jurisdiction,
Yes,
yes. Okay. And I think as propriety and so many important issues are coming up before the board, I think we should all be here, and if we can't be here, it should be a video conference, an active live video
In
conference.
person, yeah.
Yes, if they can't be here in person, yes.
So quickly, I'm going to run through these. This is more on your staff, but just to make sure that you understand. The only thing that can be discussed at a meeting is something that is on an agenda that's been duly noticed, and that's why you've got that certificate of notification about your agenda posting. Agenda has to contain a brief general description of each item to be discussed. It specifies the time and location of the meeting. Regular meetings must be posted at least 72 hours prior to the meeting in the public location and website, as Ray indicated. And the agenda has to provide the opportunity for public comment on on items not on the agenda but relevant to the board, and items that come before, each item that comes before the supervisors that you're going to actually deliberate, weigh, or make a decision on as well. So most agendas have multiple public comment period, because it's on each agenda item plus a general time for items not on the agenda. Special meetings. Today's a special meeting. Must be 24-hour notice to both the legislative body and the media and members of the public. Notice also contains a brief general description of each item to be discussed, and no other business can be considered. If it's not on the agenda, you can't talk about it. Emergency situations. There's an earthquake, there's a flood, there's some, civil unrest. There may be an emergency situation that is so disruptive or threatening to the public facilities, and then you have to do a 1-hour notice to the media, and no closed session items can be heard at an emergency meeting. You can have a closed session at a special meeting, but not an emergency meeting. Exceptions,
Can you repeat that? You're saying in a special meeting,
So
there is
special-
no closed session whatsoever?
no, emergency meeting.
Oh, emergency, okay.
Okay.
I mean, that's what I
There
meant.
is
An
a
emergency meeting,
regular
there's no
meeting.
closed session.
Right, there's a regular meeting,
Emergency meetings,
Us-
we've never had one. It's the one that's called within 1 hour
With,
notice.
with 1 hour, okay,
1
because
hour.
we had special meetings.
All
Special
the
meetings,
time.
you can have
Right.
closed session.
Right.
That's when we,
Never had an emergency
the only
meeting.
reason I bring it back is because we had a flood here 4 years ago, and we had a couple of emergency, or not emergency, I should say, special meetings,
Yeah.
and we had a closed session.
right. And again, the closed session is only 24-hour notice. Emergency meetings, I don't know any agencies barring the Loma Prieta earthquake and things like that, where any agency did that it was so critical to just convene right away. And those have to be open to the extent that you can even access your facility and things like that. Exceptions to the agenda requirements. So what do you do? It happens every meeting. A member of the public gets up during a public comment period, and they make a comment on something not on your agenda for that meeting. What do you do as a chair or supervisor? Even though it's not on the agenda, the chair can make a brief response to a public statement or questions, but they can't discuss it. You can explain to the members of the public that that item isn't on the agenda, that you're not allowed to discuss it, that you can refer them to staff members so that they can have a discussion and get answers to their questions, but you can't discuss it, but you can make a brief response. You can do brief announcements or reports on your own activities during a comment period or something that you think might be public interest. And you can provide references to staff, request staff to report back, or using your board rules, discuss about putting a matter on for a future agenda. And we'll get into later how you do that. Further exceptions. There is a limited reason to add an agenda item when something requires an immediate action and the item arose after the agenda. There's this special circumstances in the Brown Act, although generally most agencies know it at least 24 hours in advance, so you have a regular meeting, and then you convene a special meeting to handle that one item. I'll defer to Barbara or Ray, I've actually never seen this used where things are so exigent, it's such an emergency, that on the night of, or the day of your board meeting, you actually add an item to your agenda.
We had.
I've
we've
seen.
had-
I've
We
se-
have
I-
done
Yeah,
it,
I've
yeah.
seen it.
Yeah.
That was the.
Limited circumstance.
But it's very limited.
Yeah.
I could probably count it on one hand.
Yeah, that was
time
the
I've been here.
individual that was being transported from, there was one that we had, there was a transportation issue from the jail.
I remember that.
That was the only one I remember in 4 years.
Okay. But
And
as you
most
can
of the-
see,
Oh, go ahead.
that it's just an exception.
And most of the time, we weren't aware of it until that,
we didn't know until
basically,
that
and
morning,
then
yeah.
timing is of the essence. We have to have something executed maybe the next day or something,
The
so.
one that I think that was being referenced was when a child that was in dependent care had to be transported out of state.
Oh,
and
that's-
They needed
that's the one.
approval
Okay.
to transport them because there was out-of-state travel.
And we
Right.
found out we found out during the meeting, actually.
Right.
Yeah.
What we called, right?
Yeah.
Yeah.
So there
Oh.
is a way to do that, and then there's a process. You can't, 2/3 of the board members present have to add that item to the agenda. Closed sessions, can you meet outside of a regular meeting with the public? Yes, but only on personnel matters, pending or potential litigation and legal advice, real estate negotiations, lease negotiations, or labor negotiations. Very, very limited reasons that you can meet in a closed session. And just because I know the planning commission is on, planning commission has no basis for, generally for, unless it's pending litigation that they have to be updated by the county counsel's office, or they're involved in any kind of real estate or lease negotiations. But generally, except for the Board of Supervisors, there's very rare exceptions for any other board or commission to meet in closed session other than the Board of Supervisors.
And there's one or two more that we don't usually use, but like, I think it's claims against, in addition, there's a couple little minor ones that don't come up very often.
Personnel matters. Appointment, employment, evaluation of performance, discipline, or dismissal of one of your employees, your appointees. So that would be
As
the.
three
chief ad-
employees.
Yeah, chief administrative officer, your county council, and,
The Ag Commissioner. Those are the three that.
so those are
can
the
meet in
three
closed session.
employees that you get to meet on appointment, employment, evaluation, discipline, or dismissal. If it is a other type of employee, that's not in your purview, that's in the CAO's purview, and he can bring matters to you, but not necessarily, in the same context. Okay, you can consider complaints or charges against one of your appointees, those three employees, and that employee must be given 24 hours' notice before you meet, and the right to hear if there's any charges in open session. And that has happened in a lot of jurisdictions, that your chief administrative officer or county council or someone takes exception to the board, convening, and they want this to be in an open matter, not a closed session, and that's their choice. Pending litigation advice from legal counsel. Closed session may be held to receive advice from legal counsel regarding pending litigation where discussion in open session would prejudice the agency. Pending litigation is limited to existing litigation, decision on sometimes if the county wants to initiate litigation, and situations involving significant exposure to litigation, where you know ahead of time that something's happened, there's a landslide, there's a serious accident, something that's happened in the county that might involve significant exposure to litigation. And if there is significant exposure to litigation, it has to meet one of these criteria. There's either a claim that's been filed or written communication threatening litigation. There's been a verbal statement. Somebody stands up in a meeting and says, I'm going to sue the board, I'm going to sue the county, I'm going to sue you because of X, Y, or Z. Or that the county is aware that there's facts and circumstances that you can articulate that might result in litigation that you've learned. So there are still some limitations on litigation about meeting in closed session. And conceivably, if it's appropriate, the county council could meet with the planning commission in closed session on pending litigation, if they thought that the threats were made related to one of their actions. Real estate negotiations. Everybody's aware that if the county is negotiating for the sale or purchase or lease of real property or any kind of an exchange, that makes sense. You don't want to have to tip your hand You'd be in an unequal bargaining position, negotiating position, if you couldn't meet in closed session. But what's not all known is that you do have to disclose what the parcel is you're meeting about. You can't just meet and put on the agenda that you want to meet about real estate negotiations without identifying the location of the property. So if you may tip your hand if it's not available, but you think it's going to be available and you want to be poised and ready to react, you still have to list that parcel. You have to let the public know that you're at least going to meet on a specific address. The other thing is that you can only talk about price and terms of that negotiation. All the other land use matters about what you might do with that parcel or housing or any of those other considerations aren't part of the closed session. Labor negotiations, that's probably going to be one of your more frequent reasons to, not frequent, but regular reasons to meet in closed session. You can meet in closed session with the agency's representative. That may be a lawyer, that may be your bargainer, your negotiator in labor negotiations with both represented and unrepresented. So your union and your unrepresented employees groups, you can meet to discuss labor negotiations. Questions? Okay. And again, prior to the open session, before you go into closed session, you have to engage in an open session to identify who the agency, who the Board of Supervisors, who the county's representative is. Okay. How should closed sessions be handled? Do you have a very capable and competent county counsel that will guide you in this? You have to follow the statutory language. There is what's called safe harbor provisions. In the Brown Act, the language about how you list a closed session item is in the statutory language in the California Code. And if you follow that language, then it is presumed that you have, adequately disclosed it. But, so you follow the statutory language about how you identify a closed session. And then you announce to the public that you're going to convene in closed session. And you can only have the Board of Supervisors, your attorney, your CAO, and any other appropriate attendee in closed session. If it's a litigation matter involving the sheriffs, then maybe a representative is in there. Ray or Barbara, I'm going to defer to you. Do you usually have staff in closed sessions?
Yes, we
Yeah,
do.
okay.
With relevant staff on closed sessions.
That are relevant to that issue.
To that issue.
Right, okay. And the other key thing that your county council or will work with your board chair, there is some required reporting following a closed session to let the public know whether you took action or no action, reportable action was taken. So what happens as a Board of Supervisor? Can you talk about what happens in a closed session? The answer is no. No disclosure of confidential closed session information. As much as you want to inform the public, until the Board of Supervisors decides that that information is public, individually, you cannot disclose what happens in a closed session, who says what, who on a labor negotiation, who gave a thumbs up or a thumbs down, voted for, a certain provision. And there are penalties that, for disclosure, someone can not only sue the county, but an individual Board of Supervisor for a breach of the confidentiality. There can also be referrals to grand juries for those types of violations. And I don't mean to make light of it. I mean, that's a serious issue that you want to avoid.
Let me just jump in on that.
Sure.
Closed session is something extremely serious. And the 5 members that we have on this board, I have trust, faith, that we will not breach confidentiality. And to me, that's everything. I do not ever want to hear of anyone ever speaking about something that happened in closed session out in the public, because to me, that just, it eliminates all the trust we have with each other. And that's probably one of the most important things, because in closed session, we do say things that, that are meant for us to make appropriate decisions. So that's just, I want to make sure it's extremely important, and it is, you know, I'm happy that there is a penalty that you're saying that can transpire if that confidentiality was broken.
I had a question on that also. I had put in my notes here, consequence of disclosure, and so I appreciate that. So how would the procedure happen if, in the event one of us inadvertently, intentionally or otherwise, went ahead and disclosed something from the closed session, and it had a material impact on the community? How would you be dealing with that?
I think it's this is my thought, that it's appropriate for it to be addressed at the board level, not necessarily brought up by staff, so I think that the chair could agendize that. There's various different remedies. I mean, the board could discuss whether or not there should be a referral, whether there should be a censor, whether there should be just public criticism, but that would probably happen at the board level to talk about that issue.
Okay.
What, a question, what happens if a member of the public, you know, they may not know what's going to happen, but they know there's something that's going to go into a closed session, and they, you know, they call you or whatever, and they comment or they give you input or what, is that, I mean, should you not even listen? I mean, obviously you can't talk about anything that takes place, but I'm just curious.
You
Is
can
that-
always listen to your constituents, and your member of the public can always contact you. Your decision, what kind of input you want and what kind of meetings and calls you want to take, people can email you. But, you know, you can't confirm or deny anything other than what was on the agenda, that there was a closed session about labor negotiations or a real estate transaction. It is a slippery slope, and as Supervisor Medina says, it goes to the heart of the trust for an elected body. So not only is it may subject you, there can be referrals to the district attorney's office for criminal penalties, and that can be done by, you know, your board, like, or a member of the public or staff, as uncomfortable as that could be. And then there can be civil actions to, for an injunction to stop the action. Somebody that is somehow impacted it could sue the county and the individual board member who allegedly conducted the violation, to invalidate the actions or mandate corrections and things like that. And again, you're going to learn from your county council and CAO that every time that the county's involved in litigation matters, it always is going to be a weigh and balance of what the court costs and attorney's fees, and, you know, what that's going to mean to the county coffers. So
Back to Supervisor Tiffany's issue, the board, when it gets into labor negotiations, although each board member can meet with the labor unions, the board, you know, may at some point decide whether or not they want individual board members to meet, or whether or not they want more of the negotiations to go through the negotiator, and, you know, that's at a future point in time, and it can be handled different ways.
Historically, I think the board has taken on the point to obviously meet with everybody during normal times, right? Normal. But once we get into negotiations and the table, that's when usually the board members pull back a little bit, because that's a slippery slope, you know. There can be a divulging of information. This becomes a little bit, the increase or the possibility of direct dealing or other things can come up, which I think is one of the reasons why historically board members have pulled back a little bit on communication and allowed our labor teams to do the negotiations at that point with the board's direction.
But like, for example, I mean, I'll just use one that I'm aware of, well, maybe I won't. Because it's under closed sessions, I don't know that I wouldn't even bring it up. Let me ask a totally different question, but related to closed session. So you go into a closed session, let's say, on Tuesday here, where there's gonna be closed session. We just got done talking about a hot issue. We go into closed session, I'm sure that you have to be very careful that you don't carry on some kind of conversation about an unrelated item that's not a closed session item, but I can see that, potentially happens if there's a hot issue. I'm curious to touch on that. I assume you have to be very careful.
Yeah.
Yeah.
You just can't do it. And when you go back there, you can only meet regarding the items that are on that agenda.
Yeah.
And you could be assured that staff's going to remind you of that during your closed session if you get off topic and go beyond the close. Well, most likely, you're going to be reminded of what the constraints are during your closed session. The 5 of you won't be meeting by yourselves. You're always going to have your attorney or CAO or somebody in that closed session with you that's going to be familiar with the sideboards on what you can and can't talk about.
Right.
Yeah.
Okay?
So I'm not sure. I just wanted to take a quick poll with the board. Did you guys want to take a 5-minute recess, or do you want to just continue on?
I don't mind continuing on because I took a ladies' break, but I would like to have the heater on. I'm freezing, my fingers are freezing.
Yeah, the other.
It's not in the budget, sorry.
Are you referring to the restroom or?
Yeah, for restroom break.
You wanna-
All right, let's
I
just
could-
do a
I could
5-minute recess for
I can
bathroom break.
bring my little heater down just
Yeah.
in case they want.
I have a sweater in the car. It doesn't match with what I'm wearing, but if I have to put it on, I will.
It's not in the budget already, I told you.
He said,
It's not in the budget.
freeze.
See, is there a little outlet there?
I'm just gonna.
Up there. I'm gonna go bring you down a blanket myself.
All right, I'd like to go ahead and reconvene the meeting, or our training session. You might be able to sit down. Yeah, no, I don't have them. It's all good. It's all good. Yeah, real quick,
Cool.
all right, so I want to go ahead and reconvene. And one of the things I'd like to highlight as a reference point for a future chair or vice chair is normally questions. So I know that there was some questions there. Since the topic is such a long topic, I think what I'm going to do on this is go ahead and ask maybe some questions from the outside. I know there's some planning commissioners on. I think that there's some relevant, probably, questions from them. I think that they would like to partake, and I know that there were some hands being raised online. So with that, I'd like you to turn to the rules and procedures of the Board of Supervisors, County San Benito PDF file. And in there is a public input section that you can look at. Maybe you can look at your convenience later. We can talk about it a little bit more on my part. But just keep in mind that, normally you can ask the public for some input. Normally it's 3 minutes. That's been historically what we have done and what we have documented. There is also, just an FYI, there is also a public comment section when it comes to the public comments within the board meetings right before the department head announcement. So that whole section is an area that you can actually read off if you like, and defines, the public comment for you. So when you actually are
Ray?
facilitating the meeting,
On
be easier.
public comment, I was watching, I think it was Orange County or another board meeting, and they limit public comment to 3 minutes, or there was another one that if it's on the same subject over a time frame. Is that common, and have we ever instituted that?
No, we've never instituted that. I have seen it. So what you're talking about is that each agenda item will be limited to, like, let's say 30 minutes,
Yes.
10 public comments. I haven't seen that as common, but I have noticed that.
And so that can
and-
be, oh, go ahead, sorry.
What I personally like instead of that item is, I also have seen another variant of that people are limited to a total of 15 minutes public comment throughout the whole day, so that they can talk 3 minutes on 5 different agenda items. But if they're going to talk on 8 different agenda items, then they have to reduce their time limit on each agenda item, which is another
Right.
variant. But we have not capped
Yeah, I just,
or
yeah,
considered
we
we
capping.
can talk about that later on, because
Yeah.
personally, I mean, I'll give you mine, is I think it's, you're muffling the
The public.
public.
Yeah.
So, I mean,
And I-
that's just me, that's.
Right.
And I think, yeah, go ahead.
I'm sorry. Let's say that you have, I think it's fair, like on a big item, if there's going to be 100 members of the public that want to comment, the way that I would do it is to reduce the time limit from 3 minutes to 2 minutes. For example, if you have 100 people that are in the audience that want to speak.
And we legally have the authority to do that?
Yes,
Okay,
you can do
that's-
that.
All right, so with that being said, thank you for the
You know.
comment. No, I know, that's great. And this is what this is about today. It's about asking questions. And I think, there's a lot of potentially, looking at these rules and procedures, and maybe adjusting them later. Maybe, and I think at the end of the day, the board historically has wanted input from the public, so they've never really put caps in some of these things. I think some jurisdictions that are really large, maybe the Riverside counties and the really, really large counties that maybe have a lot of input, I mean, they can be there for 2 days straight taking comments. So I think that's the reason why they put in some of these other caps, to be able to limit that. So it's just, for us, I think it's been working well the way we have it. So with that, I'd like to go ahead and open up the Zoom or in public here for open comment. So I'd like to pass this to Gracie.
Members of the public who wish to speak, please press star 9 or the raise your hand
We don't
icon.
have to, but.
Okay.
Elia, please state your full name for the record. You will have 3 minutes.
So you had up there that it said conflict of interest, and I'm driving, so I hope y'all can hear me well. My question with regards to your title of conflict of interest, is it a conflict of interest for a supervisor to uphold his or her oath, which is to, uphold whatever laws are out there, because they are legislative, and there is a mandate by the governor. So is it a conflict of interest for that supervisor under his or her title as a supervisor to give notice to the public not to follow that mandate? Thank you.
I don't know that we're going to.
Any other questions?
Yeah.
Well, yeah, we may go back and maybe tally these up and maybe respond to them in a bit. Go ahead.
We have no more speakers via Zoom at this time.
Okay. I don't know if you want to comment on that item or any.
Or do you want to do the public presentation on conflict of interest first?
Conflicts of interest, as I tee it up, is going to
That's
be the ethics laws and principles regarding when a supervisor or a planning commission member can participate. It won't address the issue that the speaker just asked. I'll defer to staff at either this time or a later time. That's a different question about not covered under the conflicts of interest.
We can cover that after if you want. Just continue on, but I'd like to respond to that if we can. And if we have to respond at a later date, we can do that as well on Tuesday.
Okay. Conflicts of interest. So all of you that are sitting up here got elected at some point in time, and you've all had some exposure to the concept of conflicts of interest and the rules under state law. These are all state law rules. And this is going to be more as to your role now, not as a candidate, but now as an elected official. Stop me if you've got questions. I'm going to run through this. It's important. I think Ray's going to chime in on a number of these things. And we'll, because it's a lot of detail. Public office is a position of trust. And under California law, public officials and employees must act with integrity, fairness, accountability, and honesty. We all talked about under the Brown Act that you have to be open and transparent. Under California law on conflicts of interest, you have to show integrity, fairness, accountability, and honesty. And those are statutorily based. They're based on regulations at the state level from the Fair Political Practice Commission, from Attorney General opinions in cases. And the principles are that you have to act no personal gain. Your actions can't be for the benefit of you, your business, or, family members. It has to be for the benefit of the public. No personal advantages or perks. You used to read those stories back in the day about elected officials or judges going golfing on somebody else's dime and things like that. And again, it has to be that in your role as an elected or appointed official, that you're not taking action for your own personal advantage. Has to be a fair process. And again, we've talked all morning about government transparency, open, available to the public, participatory by the public. Okay, the laws we're talking about now are a minimum standard. It's the floor. Lots of agencies have a higher bar. That's up to your board and your county. But these are the minimum standards, not the maximum. And one of the questions that you'll want to ask yourself all along in this section is the same thing that Supervisor Medina said before, is what's it going to look like if your comments or actions show up in, the newspaper or the public or on social media or somehow does it pass the smell test? How will my actions be perceived by the public? Even if you are allowed to do it, is it the right thing to do? So again, this is, there are minimum standards, and then there are going to be how you as individual elected officials apply that to your own position. These are the mandatory minimum standards. A public official may not make, participate in making, or in any way use the office or the position to influence a governmental decision in which you know that you, or should know, that you have a financial interest. And again, we'll break these down one by one, so just bear with me as I run through this. Reasonable foreseeability, we'll talk about what that means, that the decision will have a material financial effect different than the effect on the general public, that you as an elected official or appointed official, like a planning commissioner, that it's either going to affect you, your immediate family, or your specific economic interests. And that's a financial interest. So let's break it down. Fair Political Practice Commission currently has a 4-part test. And I will tell you that if you've ever been on a board or commission before, either in this county or anywhere else, the FPPC, as it's referred to, often changes that test. And we'll go back through, Barbara asked me a question just the other day about one of the prior tests that they used to use. So throughout your election and or appointment for the planning commissioners, these rules may change, they may be modified, massaged in any way. They're not set in standard, they evolve just like the Brown Act has evolved into social media arena. Okay, what does it mean to be reasonably foreseeable that a government decision, whether it's a legislative act, you're considering an ordinance banning something or allowing something, or a quasi-judicial act to approve a permit or a development project, is it reasonably foreseeable that your decision would have a financial effect on and on any of your financial interests? So what is the FPPC? What does the state look like? Foreseeability, you look at, is it possible? And it's not only a profit, you have to say, is there any economic change? Is it realistic possibility? Is it more than probable that a position that you take could benefit or harm you or your family members and your economic interests? The FPPC, the state law, says that it's presumed that there's a financial effect. It's foreseeable if the financial interest is explicitly involved in the decision. And we'll talk about how that applies to approving a contract or land use entitlements. Okay, what's a financial interest? Real property, and that now includes leases. So it's not just it didn't used to, but now it's an ownership and an interest in real property, business investments, gift. There are gift limits, and I know you probably looked at that when you ran your own candidacies. You look at what your sources of income are and what that personal financial effect may be. One of the steps that the FPPC looks at, and part of the analysis that you would look at in trying to determine if you had a conflict, is whether you have a direct or indirect investment of $2,000 or more in a fair market value in either a lease, a long-term lease, or real property located on property within your jurisdiction. So again, the real property that's subject for Board of Supervisors or Planning Commission is the property within San Benito County. Nobody cares, it's not an issue if you've got property elsewhere in the state or out of state. It's what's your financial interest in property within the confines of County of San Benito. What are your investments? And investments include investments of a spouse or a domestic partner that are registered under state law. And what's your position in a business entity if you have a 10% or greater interest in it? So it's not just that you own a business, but even if you only have a 10% interest in a business, and it might be a family business or something like that, you have to look at those indirect investments as well. So any business doing business in the jurisdiction, and again, all of this is premised on your activities within the confines of the County of San Benito, has a direct or indirect investment worth $2,000 or more, or, it's an or, not an and, you're a director, an officer, a partner, a trustee, might even be just a management employee or holds a management position in a company. If you are benefit in your income in your company, you hold a position of such trust that your decisions on the Board of Supervisors might impact the company that you work for, even if you're just an employee or a management employee, or even if you're not an owner, you might have to look at that as well. Other indirect investments is source of gifts of the new gift limit in California for elected officials are $520 or more in a 12-month period prior to the decision. So you have to look at that as well, and we'll talk about gift limits. These are just sort of your investment categories. Any source of income, $500 or more, provided to or promised to the official in the 12 months prior to the decision. You're going to see that that may come into play is if you are on some sort of commission. We've had real estate agents, mortgage brokers, things that people who are in elected positions that get compensated by commission, and that $500 will trigger a commission. So if you're in one of those industries, that's worth looking at and talking to county council staff to help you analyze these kinds of potential conflicts, economic conflicts. You also have an economic interest in a government decision if you or your immediate family personal expenses, incomes, assets, or liabilities are likely to go up or down by a measurable amount as a result of your decision. So one of the things that most people do the analysis is they say, well, I'm not going to have any economic gain. I'm going to have a loss so I can participate. Under the rules in California, if you or your immediate family would suffer an economic loss by a measurable amount, and again, there's those standards, it's for each category, you have to analyze that as well. An immediate family in California is defined as spouse-dependent children, and a spouse includes a registered domestic partner. So is the foreseeable financial effect material? So what's the threshold? You already know it's a complex issue. You have to look at each of those levels. $2,000 for real property, 10% interest in a company, $2,000 for a business interest, $520, it's a gift. So there's different categories that you have to do the analysis for. And a key issue in deciding on whether you have a conflict or not to be able to decide or participate in a project in a decision would be, what's your financial interest? And the next step, step 3 is, can you show that this material, once you've decided that there is a financial interest, and then step 2, it's a material financial interest. Step 3 is your position different from the general public? If you're deciding whether to allocate funds to a roadway project or street improvement project in the county, and it's in your neighborhood, you might have a material financial effect. It might impact the value of your property if you're an owner or have a long-term lease on a residential or business property. If that roadway project, that street improvement project is in 10 locations, or it's a capital improvement project for the entire county, and you're just going to be allocating who goes first, and you're all going to have your roads improved, then maybe the analysis is that you're no different than from the significant segment of the public. You stand in the same shoes as your neighbor in District 4 or District 2 or whatever, then you may be able to participate. And you also have to look at whether your financial interest, whether it's unique or not unique compared to this significant segment of the public. Do you own all the property in an area? Do you own just 1% of the property in the area? So these are questions, and then we'll talk about how you actually get those questions answered. The most important thing I think I want you to take away from this whole discussion, and I think what staff is going to want you to take away is for your own protection, is after you go through the 3-step analysis under the Fair Political Practice Commission, and it's been determined that you have a conflict of interest, and it doesn't appear that there's any exception or exemption, you not only can you not sit as a supervisor and participate in that decision. You can't make the decision, you can't participate in making the decision, but you can't use your position to try and influence that decision. So that may mean, getting back to the discussion about who and when you can talk to, if you can't participate because you've got a conflict of interest, a financial conflict of interest, not only can you not make the decision, you can't sit and vote on it, you can't participate, so you can't be up on the dais engaging in discussions. But even before it comes to the board, you can't be the leader of some neighborhood group and be feeding them information or meeting with your other board members trying to sway their position when you have a financial economic interest in the outcome of the decision. So it's a multi-step consideration, but again, I think everybody gets that you can't participate, you can't be in the discussion, you can't vote on it, but keep in mind you can't do anything to further or influence that decision that comes before you. So how that happens on step 4 is once I know, you don't even know if you have an economic interest. I'm jumping to, let's presume you do. You have to abstain from any participation or any influence in that decision. And then what the rule has always been is, let's say that you can't participate in a decision because you have a financial conflict of interest. You have to state that economic interest. It's not enough to just say, I'm not going to be participating in item 2 on the agenda because I have an economic interest in this project. You have to say, I own property, I have a 10% interest in a business, or whatever the determination of your economic interest you have to disclose that on the record at a meeting before the item is heard. And that would be true of some of your staff members, like your county council or your chief administrative officer or your ag commissioner would be in that same position. And anyone in the county who manages public investments. And you have to actually step off the dais and leave the room. There's all these cases about, back in the day when this statute became relevant and adopted by the legislature, that there was concern that if you stayed in the room, somehow you were going to signal either intentionally or inadvertently to your fellow board members and somehow influence their decision. That you're going to sigh, you're going to, cross your arms, you're going to do something physical to somehow influence them while they're on the dais having this discussion. The new rule as of in 2021 that was adopted in the last legislative session says that if you have a conflict of interest and you are must recuse yourself, this is misleading, you actually have to recuse yourself from any participation. Let's say the item is the first agenda item, and you talk to Ray and you say, I can't participate in that first agenda item. I'm going to come an hour later to the meeting because I'll just come late to the meeting and I won't be there for that agenda item. Now, under the new rules, that when you come into the room, even if it's, let's say that Supervisor Tiffany, you have a conflict of interest, you can't participate in item number 1 on the agenda, and you decide to not, since you can't participate, you're not even going to be here for the Pledge of Allegiance, and you're not going to come to the board meeting until after that, or you're not going to log on Zoom until after that item has been heard. Now, when you come onto the dais and you start your participation, you can no longer avoid stating your conflict of interest. Now you have to say, oh, and before we move on to item agenda 2, I'm now participating in the rest of the agenda, but I wasn't present for agenda item number 1 because I had a conflict of interest, and here was my economic interest in that. You used to be able to avoid that by just not being in the room and not being, or if you're absent from a meeting, you don't have to, like the next meeting, you don't have to do that. But if you're going to participate in part of the agenda, but not all of the agenda, you at some point in time have to state your conflict of interest on the rule. And that is new. And you'll work with county council about, and the chief administrative officer about how that gets woven into the agenda process, because that will be a new part of the 2021 requirements. Okay. Consequences of participation. If you've wrongfully participated in a decision in which you had a conflict, that agency decision may be invalidated. If your failure to disclose and it was intentional to not disclose and recuse yourself, you could be prosecuted. You could face civil penalties, and it could result in a removal from office. Public generally exception, we talked about that a little bit, and the new requirements are, there's a test for, are you in the same shoes as everyone else? Do you sit in that same position as all of the other board members or all of the other community members? And even if you had a financial interest, you might be able to participate. Rule of necessity, there's an exception in law is, let's say 3 supervisors have a conflict on the same project. There is a process by which members that have a conflict disclose the conflict because you need a quorum to vote on an item might have an opportunity, despite their conflict, to participate. And then there's special rules on how you do that.
I have a question.
Sure.
So isn't there also something in regards, I'm thinking in terms of property, in terms of distance from, let's say, home, and I'm thinking specifically
The 500-foot rule.
500
Okay.
feet. So, and again, an example, I lived
So-
at okay, go ahead.
So let me jump in. That's what Barbara and I were talking about. The land use rule always was for conflicts of interest, 500 feet. And then it was like 300 feet, and then it was inside the jurisdiction, outside the jurisdiction, whatever. The FPPC now is looking at a value of it's just this four-step process, whether it is a land use decision about where your property is. It's not where your property is, it's that you have this financial interest of $2,000 or more fair market value in a property that the decision may affect. So they don't even look at whether you're 300 feet, 500 feet, or anything. It's totally on, if you own property with a value of $2,000 or more in a lease or a real property, and there is a foreseeable material impact to your property, up or down, related to this decision, then you're going to be conflicted out of participating. So it's no longer a firm. But most jurisdictions, and I don't know what you guys are doing, and certainly with the Planning Commission, will usually map out and kind of tell you where you are, because it may be that, here's an example of where you might look beyond 500 or, and why that isn't the current standard. If a county is building some sort of stadium, performing arts center, something that's significant value to the community, it may be that your property is 1,000 feet away, but if you're in that direct traffic flow to that new community center or something that's up for approval, that may have an impact on your property, whether you're 300, 500, or 1,000 feet away. So it really looks at what your economic interest, your foreseeability, and is a reasonable belief that you might have an economic interest. So here's what happens in the day-to-day. You get your agenda packet, and you start reading through it, and you go through all of these items. And it is incumbent on each elected and appointed official, as you go through your agenda packet or you get information about items that may come before you, to really think about, wow, do I have a real property interest? Does my immediate family have an interest? Do I have an investment interest or a real property business investment, source of income, my employment, or some other personal financial effect, gain or loss in this matter? Then, for your own protection, that's when you contact the staff. You contact Ray, you contact Barbara and say, I don't know, either I do have a conflict because you just know you do, because you've gone through this analysis yourself, or you contact staff and say, I need help. Do you think I have a conflict? Can we go through the information? And generally, at that level, you can decide whether you do or don't have a conflict. Occasionally, a supervisor or even a planning commissioner will say, I know this is what you're telling me, I have a conflict, but I think I can participate and I shouldn't have a conflict. And there is a process that either the county council or you can ask the Fair Political Practice Commission for a written opinion about whether you do or don't have a conflict of interest under the state law. You can also get informal advice from the FPPC, but that won't protect you or binding if there's a challenge. So there's different levels of ways to get help on whether or not you have a conflict of interest. I know this sounds complicated, but honestly, most elected officials know when they have a financial interest in a project or not. And it might not even be a project, it might be a legislative act, it might be an ordinance that either allows something, as counties and cities were trying to work on cannabis issues, if a supervisor had some sort of an interest in a property that was being viewed for potential growth or sale of cannabis products or an interest in a business, then even on the legislative act, you may or may not be able to participate. And generally, I think it's rare that an elected or appointed official, sometimes, there are circumstances in a meeting where you're going to say, oh my gosh, as I listen to things, you realize that you didn't really think about that before. That's a time to ask for a break and talk to, your appointees and figure out whether or not you can or can't participate. So there's also a difference. What financial interest, if you do have one, it's mandatory. You may not participate. It's a state statute. There are ramifications if you do participate. And that's what's called a recusal. You have to recuse yourself. You have to not participate, make, or participate or influence the decision at all. You step off the dais, you step off the room. What happens if you just don't want to participate? Is that the same thing? That's called an abstention. And lots of board policies have direction on abstentions. And I'm going to defer to Ray, but most jurisdictions don't favor abstentions. You were elected to participate. That's a personal decision. You may have a reason. You don't have to state your reason for abstaining, but generally, that is not a favored approach for most elected officials because you want to participate. Your constituents want you to participate, and you, when elected or appointed, agreed to participate. Ray, anything particular in?
About that, yeah, and so in your rules and procedures item, you'll notice that there is an actual call out of that under M for abstentions. I think just to note, I think what Judith's saying is absolutely true. Most of the time, though, the board members are always there, unless something. I think I've seen that once, maybe two times since I've been here, someone abstaining. But for the most part, I think your role as a supervisor is to partake and be a part of the process. And so, but there is a note there with regards to the abstention. Yeah, and it's talking about the vote and the affirmation of the vote itself as well. So in that particular item, so that's it. I don't know if that.
It doesn't
clear.
preclude them.
It doesn't.
It doesn't preclude them from doing an
That's right.
abstention if they want to, though.
That's right. That's right.
And if you're not prepared or you had some extenuating circumstance and you weren't able to participate because you needed to, site visit, do something before, there's reasons for an abstention. It's just not the favored approach. But there is a difference between an abstention, which is voluntary, and a recusal, which is mandatory. And I don't expect any of you to walk away saying, oh my gosh, I know all these rules today on this. All we want you to walk away with is the thresholds. Do you have a business investment that's over $2,000? Do you have real property or a leasehold interest over $2,000? Is your source of income greater than $500? Do you have an interest in a business entity, or are you a key employee such that your business might or employer might be impacted by this decision? Did you receive any gifts in excess of the gift amount? And do you have any, or your spouse or dependent children have any of these kinds of interests in an investment, things like that. So the point of this section is to just clue you in that these are questions you should be asking yourself as you're going through your agenda packet, or as items come to your attention from your community members that they would like you to consider these items. The question will be early on, don't wait until the meeting, because again, you can't influence a decision, so you don't want to figure out at the 11th hour that you had a conflict. Never should have been having these conversations, advocating one way or the other. The sooner you know that you have a conflict of interest, the easier it will be for you to advise your constituents, advise staff that you're not going to be able to participate in any way.
Couple questions.
Sure.
One is a little clarification on the public exception. Let's say you own a home in a neighborhood, and there's going to be, a major road work that's going to be done. That's going to not specifically affect your home, but it will be among, a whole bunch of homes that are going to be positively impacted. Is that a public exception, or because it's in your specific area and not necessarily going to be in other parts of the county, that would be an area that you would have to look at as potential conflict of interest?
And here we go again, it depends, and it's going to be fact-specific and what the...
That'd be something I probably would
and that's
just
gonna-
raise the issue
Right.
and ask the question.
Right,
Yeah.
but again, I think that having worked with elected and appointed officials for so many years, I raise that as an example because we've had that happen, and it was a real surprise to everyone because most counties and cities approve a capital improvement program, certain amount of dollars allocated for a infrastructure. And and the question became is, could this council member even participate in the infrastructure budget approval when such a significant part of that was for street improvements in a particular neighborhood in which he owned property? And so I raise those kinds of issues more as a heads up that you should be thinking as you review items about whether or not be clear about what your sources of income are, your investments and your economic interests and things like that, to at least ask the question. There's no harm in asking the question and contacting the county administrative officer or the county council and having that discussion, or for planning commissioners, contacting, their planner to at least open that discussion to figure out where you are. And again, it is a conversation. But the sooner you have the conversation, if you do need an opinion from the FPPC, that takes time. And it may limit your ability to participate if you haven't seen that in advance. Like if you know a big project's coming up and you want a ruling from the Fair Political Practice Commission, you're going to want to work with county counsel's office early to be sure that there's adequate time to get the information to FPPC and get an opinion letter back about whether you can or can't participate.
The other thing I was going to add to that is with regards to the roads, more specific to your question. In years past, we've been rolling out road projects. And so if we know in advance, or we can work with you, if there's something that does really affect your property, we have so many other roads that are being worked on, we could probably isolate that out and address it accordingly, where you still can address the rest of the county. If it does have a direct impact with you, obviously we have to go through that. But so there's notifying county council, myself in advance really would help us formulate the agenda as well. So you could remove yourself from everything else, or remove yourself from that particular item and not everything else. So,
Right.
yeah.
Okay.
So let me just tag on, there is a specific provision in the code that an agency can segment a decision. So you could recuse yourself from a portion of the item that would impact you if staff knows ahead of time to separate it out and becomes like an agenda item A and B on a roadwork project or infrastructure or something like that, and as long as they're not, tied, like, you're not horse trading, like, your project that you're interested in doesn't get funding or gets funding if they don't approve something else. But there is a way to segment agenda items so that it would allow the maximum participation by supervisors.
Okay. The other question, totally unrelated, is I gather that just as if you own property outside of your jurisdiction, it's not a concern, but also, let's say, stock investments and things like that. I guess there could be conceivably a stock you own that somehow is tied to your jurisdiction, but
Sure.
in a general sense, am I right in thinking, that's not something that is a conflict for just national stocks?
It depends on who you are and where you are and what companies. If you live in Sunnyvale, or if you're an elected official in Sunnyvale or Mountain View and you own Google or Apple stock or Cupertino, just to the north of you, that matters on a day-to-day basis for your elected and appointed officials. And that is a significant source of conflicts of interest for a lot of elected officials all up and down the Bay Area, because there's so many big corporations that are traded on the exchange. So it depends on who and what you've invested on in your jurisdiction. So I would normally say, yeah, you're probably right. If you own, it's a blended, it's a mutual fund, you don't control it, you don't trade it, whatever. But you do at least have to stop and ask the question. And if there is a significant business in located, or does business in your county, and you own stock, at least tee up the question to county council or the CAO.
Yeah, I could be wrong, I'm not aware of any publicly traded company that has headquarters in San Benito County. But obviously, people are commuting up into Santa Clara County, and I might own Google or some stock in Microsoft. I don't know, seems a bit of a stretch, but I was just curious about that.
Yeah.
I tend to agree with Judith. I think I think if there's anything specific, it'd probably be best to discuss that. But I think in general, you're probably right. Us being in Hollister, there's not a lot of trading, but there are some companies that are traded on the market. So, obviously, I think we just need to be mindful of that. And I would even caution too, if there's suppliers for some of those companies, just in the abundance of caution too, that you might want to be cognizant of. Obviously, we'd have to talk about that in depth, but that could be a possibility too.
Okay. So we've just gone through your conflicts of interest and economic interest, your financial interests, and now there is a specific code section in California law which is called 1090. It's Government Code 1090. And there's a basic rule that if a public official or an employee has a financial interest in a contract, you cannot, not only can you not participate, but the agency can't participate. So you see this a lot on like supply contracts. If you're the sole, you own a paper business, you own a computer business in your jurisdiction, there are strict limitations about whether the county can contract with you at all. Not only can you not participate, but that whole contract, the board probably can't make that contract. There are some exceptions if you are like the only supplier or of an item, or you are the only contractor that could do the work. It is an emergency, and you are the only business that can provide those services to the county. But generally, if you have a financial interest in a contract in which the county is coming before you that you're going to, have to approve or not approve, not only do you need to disclose that to staff early and often, because it's likely that that the county can't make that contract. So, and if it happens, and there's lots of circumstances where it has happened in other jurisdictions where you enter into a contract and then realize that somebody had an economic interest, that contract's void, and there may be, monetary penalties to the county because they have to terminate that contract.
And, I could say that that's a very serious issue, is to have those contracts that there are it's basically self-dealing.
So again, you have to look at your investments, your ownership and property, mostly your business dealings, what's your status in a company, what's your sources of income. And if you have an economic interest, that's something that you have to let everyone know early. And if there is a contract that doesn't come before the Board of Supervisors, but you know that it's going through your company, then you still have an obligation, even if it's in the CAO or staff level approval, you still have to alert the senior staff that there's this conflict, because it's usually only applies to contracts that the board approves or not approves, but there's a certain level of contracts that you never see. But if you're in a company, a key employee, an owner, or some business interest, and you know that that the county's considering that contract, you have an obligation to speak up and notify everybody of that conflict. Okay. Again, contract can be void. If you made any profits from that contract, you personally have to forfeit it, and there can be violations and sanctions against you for that on a 1090. And it comes back, all of this is common sense and common law. As an elected official, you have that duty of loyalty to the public, and if you think that you have any interest in something that interferes with the best interests of the public, that it benefits you or your family members, you have to avoid participating. Even if there's no statutory construction, you still have to identify it. And that goes along with that first concept of, as a public official, you owe that duty of loyalty, honesty, and integrity to, the community. Okay, questions? Okay, I'm going to run through this, but it's something that we've touched on before and it comes up with conflicts of interest, but more common law conflicts and fair process. The public is entitled to fair consideration of all items that come before you. And you've heard today that we've talked about legislative items like an ordinance or a resolution, and we'll talk about that in a little bit, where you either allow something, not allow something, take some sort of an action, or an actual permit, land use approval. But in any way, the public is entitled to a fair process. And if you've got a conflict of interest that you failed to disclose, then it puts the county and you personally at risk for failure to disclose that, because ultimately there may be a determination that you had some sort of a economic interest, the failure to disclose it, and again, does it pass the smell test? You never should have participated in the decision because it benefited you personally. So those are things that you as an elected or appointed official have to be asking yourself is, is it fair? Do I have a conflict? We'll get a little bit into bias or prejudice of a decision. And those are just, the general questions that you need to be asking yourself. And one of those things that I want to give you the example is most elected officials and many appointed officials come to their role and their duties because they're really passionate about their community. And sometimes you're passionate about one issue, and that was your platform during your election or appointment to some commission or committee. And there's always the question is, when can you participate? Have you gone too far in your commitment? Give you an example. Planning commissioner, member of the public objects to a neighbor's project. And the and appeals decisions to the planning commission, appeals decisions to the board of supervisors or a council, and is really passionate because their neighbor is building something that they don't want and they object to the project. Fast forward a couple months, planning commission appointment or planning commission position comes open. That individual applies for the planning commission and is appointed to a planning commissioner, goes through all the training and becomes a planning commissioner. When that project comes up, the neighbor's project, clearly that individual can't participate again. But the question is, when a similar project comes up, has that person so entrenched in their position on whether the height or the density of a building or something, is it fair, is it equitable, can they still participate? And that happens it's just human nature. You're here today because of your commitment to your community and your passion for the things that you believe in. And at several times, you're going to have to just take a step back and say, can I be fair? Can I be impartial? Can I participate? Or am I so committed to my beliefs that it's so black and white that I can't listen to any new information, I can't consider any other views? Then you have to kind of start to say, should I be participating at all? So those are some of the challenges that you'll have as an elected official. Okay.
And I'm assuming that would also apply to views that you might have developed prior to being elected?
Yes. And things that you have gone public and put in print, and we'll talk about that in one of the slides coming up. Okay, board roles and responsibilities. You're going to see this a couple times. The board speaks with one voice, and you take action by a majority. Sometimes hopefully it's a 5-0 vote. If it's a 4-1, a 3-2 split, you can have a difference of opinion, but the majority stands, and even if you didn't vote for it, you can talk about all the reasons that you don't support that, but the board speaks with one voice. You don't get to direct staff or take action contrary to that board majority. No individual member speaks on behalf of the board unless authorized to do so by a majority of the board to do so. Supervisor Medina spoke to that a little bit earlier about who's authorized to talk for the board. And that's a decision between the 5 of you, is who's your spokesperson. Are you able to go out in the public or be interviewed and speak on behalf of the board? No, you're able to speak on your position and your views, but unless the board has authorized you to speak for the majority, you're not authorized to represent what the board is. And you do see that sometimes if, let's say there's a project at a particular city within the county, and let's say it's even the city you live in. And let's say that you live in Hollister and you have a position on something that the Hollister City Council is taking up. You, under First Amendment, have a right as a citizen, as an individual, to go to that meeting and speak on your own behalf and your own views. What you don't have is the ability to represent, stand up and say, I am a supervisor for the county of San Benito, and we think you can't represent yourself on the board unless you've been authorized to do so. Okay?
Can I interject there?
Sure.
I think that's kind of where we have the miscommunication and misinformation on social media, where we have elected officials standing there and professing to make a statement which should be stated clearly that it's purely their own personal position. But because we're such a small community, individuals are known in the community, so the public perception is they are speaking on behalf of that jurisdiction, even though it is not the case. And so I haven't had a chance to talk to you about this, but I know that the city of Hollister wants to have a meeting with the county Board of Supervisors as well as the city of San Juan, just to see how we can kind of go forward and have a joint meeting. I don't know the crux of what needs to be discussed, but I know that that's a desire. And one of the issues that keeps coming up is the message that we're giving as individuals, that it needs to be a unified message, and that's why I keep harping on, utilizing the public information officer to the extent possible that we can, because as I know, as board members, we all have our own Facebook page, and we're making statements, and we're not speaking on behalf of this legislative body, but the public perception is we are. And so, just to kind of heads up.
And to take a little step further, we can't speak on behalf of the board as a whole, but am I thinking also that we shouldn't be speaking on behalf of our own district? I mean, maybe there's difference, it's different in different situations, but I mean, even though we represent individual districts, we ultimately are voting as an entire board. So I don't know if.
Again, you can represent your views, and you can base those views based on what you hear in either your district or another district, or anywhere in your community. But again, the best practice is to be clear about who you're speaking for. Yes. That you're speaking as an individual or a member of the public in your role as a board of supervisor, that this is what you think based on what you've heard, kind of thing. A broad representation, say, my constituents may or may not be accurate. That's your choice how you do it, but what you can't do is speak on behalf of the board. And as Commissioner or Supervisor Gonzalez pointed out, is you have to be clear about that, about who you're representing. Because there is, it's easy to blur those lines. My apologies. Most of your authority for your board, what you can and can't do, comes from state law. Your roles are your executive powers, your supervision of your key 3 county officials. We've talked about your legislative roles when you're making, amending, modifying rules, regulations for the county. Your quasi-judicial role when you are sitting as quasi-judicial as a judge in a hearing on a permit, a land use, some sort of property right. You have that hat. You also have a hat because you are overseeing county revenue, and you do sit on revenue hearings and assessment appeals, and Ray will address that. And then you also serve on regional agency boards. You have other assignments. So you wear lots and lots of hats. In the 58 counties in California, there are 44 that are general law counties, and general laws are approved by the legislature and the governor. And you are one of the 44 general law counties, and you have to follow state statutes that dictate the number, appointment, and election procedures for the county officials. There are 14 counties that have the ability to do their own rules by charter over and above state law. You are authorized as a county to make and enforce local ordinances that don't conflict with general state law. So you can regulate anything that's not regulated by state law, so long as you are not more or more permissive than state law. County has the power to sue and be sued, purchase.
Here's the question of the day, and I know it's probably highly debated, but I'm just curious.
Sure.
Being that we have to enforce or, authorize the county to make enforce local ordinances that do not conflict with the general laws of the state, does that include executive orders?
I don't know that those rise to the same level as a statutory. You can't exceed your statutory
Well, I
authority.
understand that, but that's where I'm just wondering, because I know
Yeah,
everybody's
Yeah.
debating whether it's.
Whether you can or can't.
Yeah,
I
and
don't think the courts.
yeah.
But at this-
I'm gonna tiptoe around this thing.
But at this
I don't
point in
think-
time, the state,
I don't have confidence
Yeah.
or direction from the courts of the law yet.
that's what I was asking. So the
Oh.
judiciary branch, being the state Supreme Court and the federal Supreme Court, if they came out with an opinion that stated that the executive orders were unlawful, then we would have to abide by that. Am I correct to state that?
There are already some court cases winding their way through California
Yes.
by other cities and counties. And there are some, I'm trying to think which trial court state, but have already, one of the Northern California counties, their judicial at the trial level, at the Superior Court level, has already ruled against that. But that hasn't wound itself up to the appellate court or in California or the state Supreme Court.
Exactly,
So
that's-
I don't feel confident unless, I'll defer to Barbara, but I don't feel confident to be able to say whether or not that is a violation of law or not yet.
Okay, so, yeah, we might have to talk a little bit more in depth. So,
I just want to prepare the
Yeah.
board to.
And I think that
be able
goes to
to
the
have an answer.
public
Yeah.
speaker's question about,
So-
about whether or not a supervisor that has an opinion contrary to an governor executive order is a violation of their, I think the question was, do they have to uphold the laws of the state, and is that a conflict of interest or violates their obligation? And I think the answer is, we might not know that yet, haven't heard from the courts yet, a definitive opinion as to whether or not that is something that every elected official, as part of their oath, has to uphold. If you ask most cities and counties who are suing the state right now, they would argue that, they have a right to be heard on this issue. So I don't know that that's well-settled law yet.
I mean, I can opine that if you made an ordinance saying that it's lawful to do X, Y, and Z, and the state order says it's not lawful to do X, Y, and Z, the state law or order, the guidance is going to prevail. So you cannot conflict with the state.
But we can be more strict.
You can be more strict in this regard, yes. So let me know if you want me to,
I just want the
Yeah.
board to understand also,
Yeah.
I think everybody knows what's going on, but I just want to make sure that they understand that there is the executive order. It's not a law, it's an order. And then, of course, we have ordinances that are at the county level. So that's all I wanted
right,
to.
but it can be enforced,
Yes.
yes,
Yes,
through
sir.
the state
There
law.
are lots of distinctions. under the Emergency Services Act, the governor has the authority to make rules and regulations that take effect immediately and have the force of law. But what we're talking here is a conflict of interest is different from a difference of opinion. A conflict of interest, as we've been discussing, is a financial interest. It is not a policy interest in a particular point of view on a topic of so it's people can have differences of opinion and express them. That's part of your role, to make policy, to disagree about policy, and the fact that you may or may not agree with the governor's order, or that it's prudent or appropriate to follow, and that's within your purview to do that. Again, so you can have differences of opinion. Essentially, a majority can't compel a minority member of the board to refuse to express their opinion, to prohibit them from expressing their opinion. They have a First Amendment right to have their own opinions. It's just when you act as a board, you have to count to at least 3. And in some instances, you have to count to 4. When I consider who my client is the county of San Benito. And that means at least 3 supervisors have directed me as to what my client's decision is on a matter. And there may be those of you who differ with those policies, but I'm bound by what a majority of the board, or effective majority of the board, decides and directs me to do in my capacity as an attorney for the board. So,
Yeah, and if you have
but
any
that's
other
enough.
questions, just direct them to me and we can try to get them answered at a future board
right,
meeting.
and I think we've been referring to Gallagher versus Newsom.
Yes.
That case was decided in Sutter County. The 3rd District Court of Appeal has stayed the effectiveness of that order. That's still being heard and decided by the 3rd District Court of Appeal. Other cases have raised that same issue in a direct application to the state Supreme Court. So stay tuned.
May I ask on Tuesday that we get that Gallagher as a supplement if it's not already supplied to us? I can read a court brief and I have no problem analyzing it, but just put it in clear, plain English so that if that's going to be the rule of law that we're going to be using and looking at in terms of making a determination here at the county level.
But I should say that the trial court decision was stayed at the
Right.
Court of Appeals, and the Court of Appeals hasn't issued an opinion
Right, and I
yet.
understand it's
Okay.
at the appellate level, right, but at this point, there has been a decision made.
But it's been stayed, so it's
Stayed,
not in
okay.
effect. So but I'll,
There's
happy
the
to.
challenge, there's court language, but there's just something, yeah.
Yeah.
And it's also not binding on the rest outside of Sutter County, as you pointed out. And that's what I think, it's not like we're trying to answer the questions as candidly as we can, as both Joel and Barbara indicated. There's just a lot we don't know. There are other court decisions at the trial court level that have actually upheld the executive order, and that may be beneficial, and I'll defer to Barbara and Ray about providing that information to you. It's just that is the only county that has come out so far, the judiciary, that has made that determination. So it is an outlier, and we just don't know where that's going at this point.
So we can make a decision, let's say we make a decision, an ordinance to enforce the state COVID guidelines, and we can make a decision, whether it be a 3 out of 5 or 4 out of 5, depending on circumstances. But should we not be referencing the fact that we must follow California state emergency guidelines and just make the decision on our, I don't know if,
Yeah,
Follow
I
what
think
I'm
we are
asking.
getting a little
Get a
bit
little bit
off.
Yeah.
Sorry.
excuse me?
Yeah, we'll have to address all these. These don't actually fall under the conflict of interest laws. It's a different issue about the primacy of, Constitution versus the laws of California, but we'll be sure to address that, and maybe we could talk after.
Okay. Thank
Just, and for housekeeping, why don't we take a break about 12:30? Take a 10-minute, 15-minute break?
At 12:30?
Yeah, if we can. Or where we can actually stop,
wanna
where
let
it's a
her
good spot to
finish.
stop.
I'm going to hope that we're going to be able to stop by 12:30.
Oh, cool, I'll be quiet.
Let's go
Roll
through this
on.
and see.
Wow, okay.
I don't know, maybe I'm over optimistic.
won't say anything, I promise.
No, ask questions.
You got a lot to go.
Okay. Board authority. You can only perform your authority in a regularly or specially convened meeting. You have no authority to act or make a decision, legislative, quasi-judicial, outside of a duly noticed meeting. You have no power to act for the county merely because you're members of the board. You act by decision of the majority of the board. I know, you've heard that 5 times already now. You perform your executive role when you set your priorities for the county. You're going to be having, most boards set your priorities. You oversee most county departments and programs and approve an annual budget. Your executive role is to supervise the official conduct of your appointees, the 3 that we've talked about. And your executive role is managing, controlling the county property, and appropriating and spending money on programs that meet the county's needs. So other supervisory roles as a county official's executive is you manage at a 100-foot level. You have appointees that manage at that day-to-day level. So the board doesn't have the direct control of the day-to-day operations of a department or an employee. That is delegated to your CAO, and your CAO acts based on your direction and guidance. And I think that that's a distinction that all elected officials, know that, but a member of the public will say, why didn't you, fire so-and-so? That is a day-to-day issue for your appointee, not necessarily for you as a board, if it's not one of your appointees. You supervise the official conduct of the county officers, your appointees. You require them to perform their duties, but you don't direct the day-to-day to the extent that you have those discussions with your CAO.
Yeah, one thing I'd like to add is there was some, it was a little bit convoluted there for a bit with some of our policies, because there, any kind of action like that at times would take the CAO as well as the board. So was a year or 2 years ago, we went ahead and cleaned that language up. I think we recently did some more cleanup language with the clerk of the board as well, reporting, I believe, to the CAO. So there's some cleanup language that we've actually addressed. I just wanted to make sure this board is mindful of that. We're still going through that, and look forward to actually getting some more input from you on the policies that we have internally with staff.
With that being said, Ray, the board, who are the direct reports to the board?
There are 3, the CAO, county council, and the ag commissioner.
So those 3 are the ones that we should be talking to the most about having things done at a lower level. Is that
That's correct. That's in essence what Judith
Yeah.
just mentioned, yeah.
But, well, once again,
Yeah.
it is yourself, Barbara, and Ms. Overstreet.
And keep in mind, though, from my point of view, and I've expressed this, I'm always, I think the door should be open for you to really understand as well. And where that understanding comes from is from the department heads. They are touching and feeling issues in their respective departments. I've never had an issue with board members going and wanting to get some more information. A lot of times, your board members would come to me, hey, I'm going to go, I need to go talk. That's fine.
But
There's no problem.
information is different than direction.
Well, there you go.
Just want to
And
make
that's-
sure we all understand
yes.
the information versus
Sometimes that gets
direction.
convoluted too,
Yes.
sometimes though. But and I'm really glad you mentioned that because that is important to decipher the two. Yeah.
And that's not a statutory requirement, in the sense that more departments could be direct reports to the board if the board felt to do so, but it has been delegated in this county. And the other distinction that I would say is that elected officials have, authority to run, specifically their departments. And the board primarily controls things like budget and salary of the employees within those departments and, some policies that are countywide, such as purchasing.
And specifically, she's referring to the elected department heads, the sheriff, DA, the assessor, tax collector, treasurer, and the auditor controller.
Litigation that the county is involved in. Board of Supervisors has the power to direct and control and conduct the litigation in consultation, with your county council. And it requires a 2/3 vote to employ outside attorneys to assist the county council in conducting such litigation if it's not being managed internally. And that's usually in discussions with county council. But ultimately, the decision to hire special counsel is up to the supervisors and usually based on a recommendation of senior staff. Board actions. As the legislative, your hat as a legislature, the board may act by resolution, board order, or by ordinance. What does that mean? A board order is a directive from the Board of Supervisors to its subordinate
You're
county
mean.
officers. You could actually, direct the CAO to do or not do something by board order. An ordinance is a local law adopted by you with all the formality of a state statute, but it's a local statute. It has the full force and effect of the law once it's adopted. The California Constitution allows a county to make or enforce within its limits all local police, sanitary, and other ordinances and regulations that don't conflict with state law. Most legislative acts are adopted by ordinance. On contrast, a resolution is an expression of an opinion or decision of a government agency adopted by a majority vote. So if you want to adopt a new law, you do it by ordinance. If you want to just do like a regulation or a direction or recognize someone, you do it by resolution. It's opinion or decision. It's not necessarily it doesn't have the same force and effect as an ordinance. Let's talk about the types of ordinances. So how ordinances are drafted are specifically guided by the government code, by the state law, the form, the content, the process by doing it. There are a couple different kinds of ordinances. There are urgency ordinances that are adopted for just what it says, urgency, and those require a 4/5 vote. So 4 out of 5 of you have to vote for an urgency ordinance, and it goes into effect immediately. And you use those sparingly just to usually do as an interim step until you have time to really have public hearings, analyze, study an issue. You often, if you think that it's something of great importance, will do an urgency ordinance more as a stopgap. They're short duration, you have to renew them, there's a whole process. But most other ordinances, regular ordinances require two readings. There's a first agenda item to introduce it, to give background, and then there's a second agenda item at a subsequent hearing that requires the actual adoption. And then an ordinance is generally not effective until 30 days after the date of adoption. So an ordinance process, if you're meeting twice a month, could really actually take 60 days to put into place. If you introduce it at your first meeting of a month, as the first reading and introduction, and the adoption is at your second meeting in the month, and then it's got 30 more days, it's almost a 60-day process to actually adopt an ordinance, or to have an ordinance be effective, I guess is the appropriate way to say that. Ordinances require statutory notices, so to the public on certain items. And again, your staff will guide you through whether it's supposed to be an ordinance, a resolution, or a board order. Okay, you've heard a lot today about your role as a judge, quasi-judicial role. Settlement of claims will come to you as a board, audit accounts related to management and disbursement of funds, and the hearing process for land use matters that Joel's going to talk about soon. Other roles that you have, you also serve on other capacities on boards, commissions, and as intergovernmental relations, you're all assigned to other duties that you do with other local agencies. State statute authorizes various service functions to be carried out by entities other than the Board of Supervisors. So sometimes you have to delegate, but you have a seat on that entity. Okay, police powers. Under the California Constitution and the U.S. Constitution, police power is the authority conferred upon states, delegated to cities and counties to enact their own laws to preserve, protect the safety, health, welfare, and morals of the community. And you will hear the term police powers numerous times, because that's generally the authority that you have to adopt your own rules and regulations. Police power is the basic right of government to make laws, regulations for the benefit of their communities, so long as it doesn't conflict with state or federal law. Only states have the right to make laws based on their police power, and the federal government, their role is to govern laws specific to the powers under the Constitution. So again, different levels of laws and who preempts who. Barbara? You wanna
Yeah,
jump in?
and so the cities and the counties obtain their police power through the state.
Yes. And the board may, and in this case has, delegated its duties to its appointees, the CAO, county council, or the ag commissioner. And you can do that by ordinance, resolution, or board order where specifically allowed by state law to delegate. There are some duties you're not able to delegate, and those specific, staff will advise you if they can't, if that's a decision you have to make as opposed to delegate. Board delegates currently the day-to-day operations to the CAO, the CAO prepares and recommends an annual budget to the board for your consideration, and the CAO in San Benito coordinates activities of the county departments to ensure implementation of the board's directions and policy. And I think that just reiterates what Ray already told you what he does. Also, is the county administrative officer shall be recognized and functioned as the CAO. They will advise, assist, and be your liaison for anything you need within the county. Their work with you for the proper and efficient administration of your affairs so that you can do the job you were elected for. They prepare and recommend to you personnel rules and revisions and amendments. The CAO also does the classification studies and plans for the county staff and makes its recommendations to you. And that is a brief overview of what that CAO's role is compared to what your role is. Okay, rules of procedure. Do I have 30 seconds?
25.
1 minute? Okay. So currently, County of San Benito has your own rules of procedure. The way you organize your meetings, the way you operate your meetings. And there is a policy regarding that. And you can work with the county council and CAO on any kinds of changes, amendments, modifications to that. We always get asked is, what about Robert's rules or Rosenberg rules? There are two sets of rules that some agencies, and I say some, use either instead or to supplement their own rules where their rules are silent. And it's just a rule of procedure. What do you do when you make a motion and there's an opposition? What do you do, how do you manage an orderly meeting? And basically, your current rules will do that. Ray asked me to just point out that there are some standard rules that other agencies use often to supplement their own. Roberts is a little challenging because it's 800 plus pages of rules, and I will speak from personal experience when I'm staffing a Board of Supervisors or Planning Commission or City Council meeting, and somebody asks me a rule of procedures, I'm probably not going to be able to plow through 816 pages of rules to come up with a really quick answer in 30 seconds. Contrasting that, there's Rosenberg's rules, and those are 6-page in length and available online, and a lot of agencies are shifting as that as the backup and away from Roberts because they're more clear, plain English, and more easily understandable and can be managed during a meeting. And again, there's no one right way, and nobody has to do any other than your own rules that have sufficed. You don't have to do anything, but if you want to know, there are other rules out there. We have a cheat sheet that we often our firm gives to elected officials and appointed officials about a quick way to run a meeting. Now, you'll need to check with Ray and Barbara about how that comports to your own rules, but this is under Rosenberg's. So it just is a quick kind of thought, like as a chair or a vice chair, oh, I have to call for a motion, I need a second, I need a quorum, how do I do these things? Benefits and burdens, that's a discussion for a future time for you folks if you're interested with the CAO's office. Okay, questions, comments?
Just one comment before we break, Ray. I just want to make sure we all up here understand that there are elected officials. They're the elections controller, auditor, that's one of them, the sheriff, the DA, the treasurer, and the assessor. Now, when it comes to the sheriff and these other agents, these other elected officials, they do not report to us. They are completely autonomous. So that's some of the issues that some of the counties have versus the city where a lot of the stuff is appointed. So I just want to make sure we all understand that if you have something to add to that, Ray.
Yeah, and I think, I'll add to that. I think historically and kind of where we're at with our elected department heads, they have all been really good. They've all just been tremendous. They're eager to work with the board. They're eager to work with administration. I have regular department head meetings. They all attend, and they take part of the ongoing operational items. They're very in tune with HR and many other things that come down the pipe. So I think we're very glad to have them. I think our county is maybe somewhat unique compared to other counties that may do really have some real issues with their elected officials. But I just wanted to share that with you. And they're always willing to work with us and as well as the board. So just wanted to highlight that.
Thank you.
And I just wanted to thank you for the excellent presentation.
Thank you for your patience and participation this morning, I know, or this afternoon. It's been a long haul.
Very helpful.
Yeah, it was an excellent presentation, and I just wanted to clarify for the board that state law has a requirement that every 2 years you obtain 2 hours of training in ethics, and that applies to planning commissioners and also staff. It's an obligation that I have. There are certain certification requirements. I'm not sure whether today's session was intended to meet that requirement.
No, it's
No.
not.
That's
We
what
have
I,
separate
now
training.
you get the bad news. Luckily, you can do the required training online, and
Yes.
most counties do it on the even years. Are you on a?
Well, I can tell you, I do know that, just I wanted to highlight and add to that, is that the new board members, they're going through training. I think you already attended one class in December. There's another class, March, I believe, and then June or July. So there's 3 classes. Some of this material will be covered in that, and that is you can account for that time. We just felt it was very important for you to hear this. And we tailored it somewhat to our county. I think that was kind of the key. Some of this is general information, but I think it's really advantageous for you to be successful to understand kind of the nuances and how this relates to us as San Benito County. So I want to thank Judith as well, and thank staff for working on this, because we did meet quite a bit over the last few months to make sure that this information was set up properly for you. And yeah.
Yeah, and one of
Thank
the
you.
topics, and I'm sure you've probably already been introduced to that, which is there's an obligation to disclose your financial interests. And we didn't
700.
cover that today, but it's an annual statement of economic interests. And so that perhaps can help you focus on the areas where you have a financial interest that might lead to a conflict of the kinds that we discussed today, and then how to deal with this situation should those conflicts arise. So get your Form 700s, assuming office statements on file, and if you have any questions about that, we'll be happy to help you as well.
And if you haven't already finished your ethics training and/or the anti-harassment, they're very, very informative, and it covers, I would say, about 90% of what we heard today. Yes.
Yeah, hopefully today was a refresher, and maybe just to highlight the things that you should be continuing to ask and be engaged on.
Good deal. All right. So with that, maybe I'll go ahead and open it up for questions from the public or anyone else maybe online. Graciela?
Members of the public who wish to speak, please press star 9 or the raise your hand icon. We have no speakers via Zoom at this time.
I'm sorry. What was that? We're not, okay, my apologies. Sorry about that. I had county council in my ear. So with that, we're finished with this item, and we'll be moving on to the next item. There's going to be some overlapping information, but why don't we take a 10, 15-minute recess and break, and then we'll come back.
Could we Ravine?
Yeah.
Okay.
So we'll be back like 1 o'clock. We'll reconvene at 1.
the zoning ordinance or zoning maps to be consistent with changes in the land use diagram for the general plan. They're also mandated to be annual progress reports on how the implementation of the general plan is going. So the general plan has, under state law, has 7 mandatory elements: land use, circulation, housing, conservation, open space, noise, and safety. But other optional elements can be added, or the elements can be combined or organized within a broad discretion of the local government adopting it. And as I mentioned before, the housing element is one that has had a great deal more attention and is often set out in a separate document because it's updated more frequently than the general plan. Other elements are frequently done. Housing elements this housing element sets goals for meeting the regional need for housing at all income levels and identifying lands for where those needs can be accommodated throughout the jurisdiction. And there are, as I say, it's complex and time-consuming to continually update it and make the necessary reports to the Department of Housing and Community Community Development, HCD. And they have overview and essentially a certification responsibility that has purse strings tied to it. So having a certified housing element is critical to receiving state funding in a number of different areas. So the adoption or amendment of the general plan or any element of the general plan requires tribal consultation. So we consult with the Native American Heritage Commission to identify the tribes that are traditionally and culturally identified with the region being affected by the general plan or other actions, and invite them to request consultation and then meet and confer with them in good faith to primarily for the purposes of protecting the cultural heritage and archaeological resources that tribe is affiliated with. So, but then the process first goes through the Planning Commission, which has kind of general plenary authority to monitor and help develop and update the general plan. And they do so through holding workshops and notice public hearings. And ultimately, they make a recommendation to the Board of Supervisors as to any amendments to the general plan. After that report of recommendations is provided to the Board of Supervisors, the board then gives notice of a public hearing and conducts public hearings before adopting the general plan. And curiously, for reasons I am not at all clear on how it happened, general plans are adopted by resolution, not by ordinance. Go figure. That's just the way the state law reads. General plan amendments may be combined with other land use approvals so as to achieve consistency between the general plan as being amended and the particular zoning or subdivision or specific plan that's under consideration. So frequently, general plan amendments are combined with other entitlement applications. Because it's a legislative act, the adoption or amendment of a general plan is subject to voter initiative or referendum. So voters can propose amendments to the general plan, and those, once the petition to put those amendments on the ballot does not require hearings be conducted by either the Planning Commission or the Board of Supervisors. It goes directly to the voters. That's one of the reasons why some people are very critical of ballot box planning, because there isn't the process to consider and have compromises reached or revisions to proposals made through the public hearing process. It just goes straight to the voters, and it's up or down. Likewise, once you go through the standard procedure for adopting a general plan amendment, it's subject to referendum. So once it's approved, within 30 days, if the voters circulate a petition with 10% of the vote that was cast for governor in the last gubernatorial election, if those signatures are certified, the changes in the general plan are suspended until such time as the election can be held. And under the referendum statutes, both referendum and initiative, that is, unless the board elects to call a special election, it would be on the next general election ballot. So it could be as long as 2 years before a vote is taken on an initiative or a referendum matter. So how a general plan is actually implemented on the ground, the first step is by zoning. So the zoning has to be consistent with the land use element of the general plan. In the context, for example, the general plan that was adopted in 2015 identifies a number of commercial nodes throughout the county. And so in order to implement those policies, zoning amendments have been proposed and approved and subject to referendum about implementing the general plan. But there is a statutory requirement that zoning must be brought into consistency with the general plan within a reasonable time. And interested parties can bring an action to compel the county to do that. So there is an enforceable obligation to conform the zoning to the general plan.
Joel, excuse me, can I ask a quick question?
Sure.
So once the general plan's adopted, it was adopted 2015, if you earlier stated that all government decisions must be consistent with the general plan. If a development, let's say, comes in front of the Planning Commission and it is consistent with the general plan, in other words, it's, let's say, provides for residential housing there, is the Planning Commission and then ultimately the Board of Supervisors obligated to approve that project if it's consistent with the general plan? I mean, often you run into these situations where you go through this long process of approving a general plan, people are supposed to give input, but then people don't. And then it's not until there's actually a project, an actual project that comes along, where then suddenly people come out of the woodwork and they may be against it or what have you. But it's consistent with the general plan. I'm just curious, what are the obligations in a situation like that?
Well, the obligation is to bring the zoning into consistency with the general plan within a reasonable time. And generally speaking, the specifics of how it's brought into consistency is subject to considerable discretion. You could do a number of different, bring it into consistency in a number of different ways. And so, for example, if at first you don't succeed, you try again until potentially the general plan itself is amended, so that that inconsistency is resolved through amendment of the general plan as opposed to amendment of the zoning to conform to the general plan.
I think it might be I might see a different question that's also being raised as far as subdivisions that were consistent with the general plan. You do not have to approve them. You still need to make subdivision findings and CEQA findings. So just, the general plan is just one step stool, one part of the stool. You have to also have the other provisions that would also be met in order for something to be approved. So just because a specific project may be consistent with the general plan, for example, maybe there's other provisions that would not require it to be adopted. You're looking at your answer was about the zoning itself needs to be consistent with the general plan, or the general plan needs to be amended to be made consistent with the zoning, right?
That's right.
Yeah.
But subdivisions is a kind of a separate issue, because again, there are lots of different ways. But essentially, approval of the subdivision map cannot be given unless it is consistent with the general plan.
Right.
But there isn't an obligation to approve a subdivision because it is consistent with the
I mean,
general plan.
I'll often see where, let's say, residents of a adjacent potential development, are questioning why are these houses going in, and then you'll see the planning department may come back and say, well, or the planning commission, this was consistent with the general plan, and that is being, the argument as to why this was approved and why we're moving forward. And so I'm just wondering
Well,
about,
to put it in the context of logic, it's a consistency for a subdivision approval is a necessary condition, but not a sufficient condition.
And also, staff, let's just say hypothetically, staff is often motivated by the policies that have been directed by the board. So if something's consistent with the general plan, it's consistent with the zoning, sometimes staff will feel that they should process that application because it is consistent with the previous policies that are put forth by the board. And then if the board doesn't believe that that's correct, then the board could, maybe not adopt it. So that's sometimes why it's being brought forward. The other thing is with residential subdivisions, certain residential subdivisions, you'd have to have specific findings not to approve, which are much more detailed, I think, than our discussion here. But, so that's also, I'll defer to Joe on that.
Right. Well, when you refer to staff has an obligation to process applications. Staff does not approve or deny applications. And in reporting on an application, they have a checklist. And one of the items on the list is it consistent with the general plan? That's a legal requirement that applies to a zoning amendment or a conditional use permit or a variance or a subdivision map. So it's something that staff is obligated to refer to, but in and of itself is not a sufficient or necessary, a sufficient reason to approve something. It would be, if it were inconsistent, it'd be a reason to deny it. But those findings are ultimately made first by the Planning Commission, based on staff recommendations, but they're not governed by the staff recommendations. If there is evidence in the record that reasonable people could disagree on, the staff could make one recommendation and the Planning Commission could make a different finding, and then when it was appealed to the board could make yet a different finding. As long as there is substantial evidence in the record to support the conclusion, if it goes to court to review it, the court is not going to overturn it because they have a different opinion about how that evidence should be considered.
Real quick on general plan amendments, I understand the county hasn't done general plan amendments in recent years.
No, that's not exactly true, because there are specific projects that in one way or another have required,
I was just going off of the staff report from the general plan update. I thought it said there hadn't been any updates to the 2015 general plan. Maybe I'm mistaken on that. But my question is, how many there's a maximum number of amendments you can do per year, I believe?
yes, you can only have 4 amendments per year, but that limit is, you can combine any number of amendments in a batch. So you could have 4 batches of amendments in a year. So it's really not a limitation on the number of amendments, depending on the ability and willingness of staff in the county to process them as batches. So,
Thank you.
any other questions? Okay. So, another finding, in addition to consistency with the general plan, it has to be, a zoning must be internally consistent, not resulting in discriminatory spot zoning, for example. But it also has to be a finding of consistency with the general public health, safety, and welfare. And that's pretty broad finding requirement. So, you can justify approval or denial on the basis of consistency with general public health, safety, and welfare in any number of different ways. So that's within a discretion of the Planning Commission and ultimately the Board of Supervisors. But again, whatever the conclusion is, should be supported by substantial evidence in the record of that determination. And again, zoning is a legislative act. It's subject to initiative and referendum. And zoning amendments can be combined with general plan amendments, specific plan adoption or amendments, subdivision map approvals, and development agreements. So it's common for a large development to have a package of all of those entitlements included in the same approval. Zoning districts, under traditional zoning, you separate uses by what are commonly perceived to be compatible or incompatible uses. Generally speaking, residential is separated from commercial, separated from industrial, separated from agricultural, to avoid the conflicts that may occur because of the characteristics of any of those uses. And then uniform standards would be applied to each of those districts. Minimum parcel size, height, bulk, setbacks, parking, sidewalks, utility undergrounding, any number of criteria that could apply through zoning. And zoning districts typically specify what are uses that are permitted as of right, and those which are permitted with a conditional use permit or a use permit. And so those that are permitted as of right would be allowed. If you're applying for something that was a conditional use, that would be a separate application for a quasi-adjudicatory decision to approve a conditional use. And so that's an example of where an adjudicatory decision would come into effect pursuant to a zoning ordinance. Conditional use permits, as I said, are quasi-adjudicatory decisions. So are variances, so are subdivision maps. And as such, they are not subject to the initiative or referendum power. You can only have initiative or referendum with regard to a legislative act. Essentially, the citizens are standing in your shoes as a legislative body to exercise your legislative power through the ballot. But they can't sit in your robes as a quasi-adjudicatory decision-making body to exercise that discretion of the application of general rules to the specific application or facts. That's a role not granted to the voters under the California Constitution. So variances are an example where you might have a parcel that has an unusual size, shape, or topographic conditions such that the usual standards that would apply in that zoning district could not be met. And so a variance could be granted to allow the development with, a reduced parcel size or setback or other standards that would otherwise apply. The Subdivision Map Act is in a separate part of the government code. It allows for the regulation and control of the design and improvement for subdivision of land for the purpose of sale, lease, or financing. There are certain exceptions to that apply to agricultural uses or leasing of commercial spaces, once they've been developed, like shopping malls or so on. But subdivision map ordinances typically include street and frontage improvement requirements, what types of utilities and how they should be configured, drainage, stormwater, landscaping, parks, school site dedication, and development impact fees are all typical conditions of approval that would be applied to a subdivision map application. Subdivisions come in large or small packages. Small package would be considered a parcel map, which is 4 or fewer lots being divided from a parcel. And the typical subdivision includes a 2-stage process: approval of a tentative map, which sets forth all of the conditions of approval, and then once those conditions are satisfied, the recording of a final map. So the Planning Commission approves the tentative map, and once the Public Works Department typically certifies that all of the conditions of approval are met, it would be presented to the Board of Supervisors to accept the final map. And that decision is generally a ministerial one. It's just saying all of the conditions of approval have been met. We're accepting the dedication of streets or parks or right-of-ways and so on as part of that approval before that map gets recorded, which would allow those parcels to be sold. The Subdivision Map Act itself includes certain mandatory timelines for review and approval, including appeals. The developer lobby has been very aggressive with the legislature in trying to refine those deadlines to expedite approval process, in part because one of the time is money in the development business. You're paying for options, you're paying for financing, and the longer it takes before you can get a return by selling things, the harder it is to be successful. So there are many other planning laws that we don't have time to go into in any detail at all, but they are related to all of these processes. The Permit Streamlining Act, which again would apply to conditional use permits, variances and the like. The Mitigation Fee Act, which establishes how to establish what mitigation fees are and how they should be handled and rights to contest them and so on. The Development Agreement Law, which is a means to essentially preserve the rights to entitle to build out a development on the basis of the laws that applied at the time the development agreement was approved. So it's typically used for larger projects with a long time horizon for development, so that if the law changes, they can still build on the basis that it was approved originally. Development agreements typically require some type of community benefit, so there's a bargaining that occurs. Ray can fill you in on that process for a number of the current existing developments in the county, and I expect we may be engaging in that with projects in the future in the area that have been under discussion or for which applications are pending. The legislature seems to think that they can solve the housing crisis by passing more laws and more requirements. And so secondary dwelling units and density bonuses are examples of things, or mandatory approvals of projects that meet certain affordable housing criteria, so on. All look very good on paper for the legislature to pat itself on the back of saying they've done something. I don't believe that the actual production of housing has measurably resulted from that. So it's an ongoing problem, and the legislature just cannot leave it alone. It gets more and more complicated every session. And with, I'm editorializing here, obviously, but a actual practical solution is much harder to achieve. Another example of land use regulation is the Surface Mining and Reclamation Act that applies, and there are a number of gravel mining and surface mining operations throughout San Benito County that are governed by that law. And that requires a determination about whether or not there's a vested right to continue mining for mines that have been in existence for a long period of time, or conditional use permits, but they also require approval of a reclamation plan. So once the resource is mined out, it's going to be returned to some state that is acceptable environmentally and otherwise. In shifting focus to environmental laws, the one that comes into play for the most part for the county is the California Environmental Quality Act, or CEQA. It's found in the Public Resources Code, and there are administrative regulations referred to as the CEQA guidelines to spell out in greater detail how CEQA should be implemented. There's also a very extensive case law interpreting CEQA, sometimes extending or confounding CEQA. It's a constantly evolving area of the law, largely because of case law developments. It applies to all discretionary governmental decisions that may cause a significant effect to the physical environment. So that's projects that the county is undertaking itself, such as the, operating the landfill, or building a new building for the county, or the issuance of permits for land use provisions. So it spells out a process for identifying, analyzing, and disclosing to the public potentially significant environmental effects, and requires that where feasible, they should be avoided or mitigated to a level less than significant, which existed prior to the project being proposed or approved. The gold standard under CEQA is the Environmental Impact Report. And the reason for that is that it has the most deferential standard for judicial review. So if your action is being challenged under CEQA, you stand the best chance of success if you've approved an EIR. It also, because what applies is what I mentioned before, the substantial evidence standard. As long as the conclusions set forth in, and findings set forth in the environmental impact report are supported by substantial evidence, even though experts or reasonable people may disagree about those conclusions, the court will approve it because it's been through the entire EIR process. EIRs also allow for the adoption for project approvals with overriding considerations. So notwithstanding the fact that a project may have significant unavoidable environmental effects, with appropriate findings about the social, cultural, or economic reasons that the project should be approved, it can be approved notwithstanding those effects. You can't do that unless you approve an EIR. But the CEQA review process is briefly first to decide whether or not CEQA applies to begin with. It doesn't. It only applies to discretionary decisions. So if it's a mandatory or ministerial approval, such as the issuance of a building permit, if all of the requirements of the for a permit are established, then there's no discretion to deny it. You simply have to grant the permit, and that's not subject to CEQA. But most of the land use decisions that we've talked about are discretionary. General plan amendments, zoning ordinance amendments, approvals of conditional use permits, variances, subdivision maps are all discretionary decisions. If you're engaged, you're going to prepare a negative declaration, mitigated negative declaration, or an EIR. You have to engage in tribal consultation, just as with a general plan amendment. So there's a process laid out for that. But CEQA begins with an initial study. It's done generally speaking, using what's referred to as the CEQA checklist, which lists all kinds of environmental concerns, and to identify potentially significant environmental effects. And if there is, again, substantial evidence that there may be a potentially significant environmental effect, the obligation under CEQA is to prepare an EIR. However, if the initial study determines that there are no significant environmental effects, you can adopt what's known as a negative declaration. Or if there would be substantial environmental effects, but it's possible to design the project to avoid or mitigate those effects to a level less than significant, you can adopt what's known as a mitigated negative declaration. The problem with, or the risk, it's not so much a problem, the risk in doing either a negative declaration or a mitigated negative declaration is that the standard for judicial review is much lower. It's known as the fair argument standard, which means if there is substantial evidence in the record that there may be a potentially significant environmental effect, then an EIR is required. So if you approve a mitigated negative declaration and there's, for example, a dispute between experts about whether or not there is a significant environmental effect, you lose. And the results of losing is that the court will then make you prepare an EIR, and the project can be suspended, a project approval suspended until such time as you prepare and certify an EIR. That can be very expensive and time-consuming. So that's why, to the extent possible, applicants and local jurisdictions want to make use of either exemptions or negative declarations or mitigated negative declarations to cut down on the time and expense of preparation of an EIR. But that could be a false economy if you end up in court and lose because of the fair argument standard. So it's really a risk analysis about who might object and on what basis do they have substantial evidence that could support a fair argument that there may be an environmental effect. So that's part of the equation that we go through in trying to evaluate what the appropriate process is. So if you're going to prepare an EIR, you have to hold a scoping meeting. After you hold a scoping meeting with resource agencies and the general public to decide what should be in the EIR, you prepare a draft EIR and publish that for public comments for a period of 30 to 45 days or longer. And then you have to prepare responses to those comments and certify a final EIR. So that process can take the minimum time kind of identified under CEQA is 180 days. I don't think I've ever seen an EIR done in that. So it's time to wind up. I am not going to go through the rest of my slides, but there are many other environmental laws that can weigh into whether or not there's significant environmental effects, Clean Air and Water, Fish and Game Code, Endangered Species Act, Farmland Preservation Act, Global Warming Solutions, and others. So thank you for your time and attention. I'm sure that we will have opportunities to discuss these subjects in much greater detail as we begin specific project reviews. I look forward to working with you on that.
Joel would be happy to come back and talk to you anytime because he has a lot of knowledge in this area.
Yeah.
Joel, it was a very good presentation. Anytime that you want more information on any of these, and he'll come back and
Yeah, I was
present.
going to let everyone know it's, Joel is someone that came on a little about a year and 3 months ago, and use him, talk to him. He's got a lot of knowledge, and we're lucky to have him here. And I appreciate all you do. So once again, he's there as to educate us, and he's educating me more than I've ever thought I would even know about planning and environmental law and everything else to do with this stuff we're talking about. So thank you, Joel.
Thank you very much. It's really a pleasure and an honor to work with the excellent staff that we have with the county, and I frequently tell Barbara this is the best job I've ever had in my career, so I'm happy to be here. Thank you.
Great.
Thank you.
Thank you, Joel. Really appreciate it.
Thank you.
Next up, we have is our county council, Barbara Thompson.
And mine's going to be the quickest.
I don't know. I don't know. Mine might be a little quicker. No.
Thanks, Joel.
I'm just gonna take it off share.
Well, no, I want share too. I
Oh.
just need my presentation up. It's on
Okay.
a disk.
Is it on the laptop?
Good
No, it was a
presentation.
little,
Hey, Bob?
it was a little, I put the thumb drive over there.
Am I speaking now?
Reminds me of
Know
your
how to share
commercial.
it?
Yeah.
What's it gonna take?
Which one is it?
Uh,
This one, the
trying to
top
go-
one?
yeah.
We have to share on Zoom.
Bob Tiffany's the only one that's on there right now.
No, it's all. This one. Share. And present. Okay. You just toggle.
Toggle with the arrows. Okay, this is going to be a fairly brief training here, and we'll be talking about some of these other issues in more depth later. So assessment appeals, you will be sitting as the County Board of Equalization to hear appeals on property valuation. Those are started with the owner filing an appeal form with the clerk of the board. There's periods of time that are involved with that. They can be waived with a signed waiver from the owner. It's a very detailed process with specific ways to introduce evidence and burdens of proof. It's very much like a hearing where one party will go first, then there'll be questions, and the other party, we have a specific procedure that's set forth. So for example, the burden of proof is different for single-family dwellings, where the burden of proof is on the assessor to show that the valuation that's proposed by the owner is incorrect and that the assessor's valuation is correct. Otherwise, the burden of proof is on the owner to show that the owner's valuation is correct, and they cannot just come into the boardroom indicating that they believe that their value is correct. Usually, it's supported by specific evidence to show how they have to show how the assessor's value was incorrect and why their valuation would be correct. The evidence is presenting regarding the valuation, the hearings under oath, and we'll have specific training regarding the assessment before the first assessment appeals boards are held. Does the board have any questions regarding that, or moving on? Okay, so county service areas, this is how we finance, in part, new development, because new development, it's pretty well known for many, many years that new development does not pay for itself, and the 1% that the county collects, of the property taxes, the county only receives a small percentage of that. I think it's about 11% overall, because the majority of it goes to state entities. So new development does not pay for itself. If you had a new development of multi-million-dollar homes, then perhaps it would. There is a cutoff amount that they've calculated over a certain dollar amount.
I don't want to interrupt you, but please, let's differentiate between CSAs and CFDs.
Yes.
Because we're going more to the CFDs. CSAs are kind of running away. I just want to make
Yes.
sure we're all on the same
Yes.
page. Sorry to bother.
We're going to cover both of
Okay,
them.
sorry, I just don't
Yes.
want to make. I wanna
It's all
make-
good.
Yes. Okay, so they're both CSAs and CFDs are both a mechanism to fund the service and to provide the service. In an ideal world, most urban level services would be provided in a city, but in the county, there's been several urban level residential subdivisions that have been formed in the county that need services provided. Traditionally, these were served by county service areas that were created. Other counties have dealt with the situation differently and formed county community service districts. Those have their own issues with serving them. I came with it from a county that had many county community service districts with varying degrees of success. So they have the ability to be managed by the board or by an independent body. But the county service areas are like little tiny areas where for specific subdivisions. So traditionally, in the old days, the county could just establish a tax, and it was placed on the tax rolls to collect money for those services and those CSAs. Then Prop 13 came along, and Prop 218, and no longer could the county just establish a tax to collect the necessary money to provide those services. There are 5 CSAs that were formed so long ago in the county that they are called AB8 entities, and they share part of the 1%, and therefore they have a funding mechanism without adopting a fee. And those are listed there. For those CSAs that have no part of the 1% and that are not an AB8 entity, we've established a fee process through a fee report, a Prop 218 process that was completed around 2009, 2010. I think we went out about 3 times to try to get as many of the CSAs to approve a fee as possible. The ones that did not approve a fee, the services were generally placed on an inactive status or only on very critical service needs, but items like roads were not actively maintained. Since it's been 10 years since services were stopped in some of the CSAs, now some of the CSAs would like to come back and become perhaps active because now the roads are no longer being maintained if they've been inactive for a 10-year period of time. This was presented in a prior report to the board that there was 32 active CSAs, but of those CSAs, only approximately 2/3 of them have active services that are actively being provided. The other ones that are still in existence, the county's going to go in a process of perhaps dealing with the ones that are not active, but these are the ones that are active plus the 5 that were mentioned previously that have the AB8. So these are the ones that actually have a fee imposed, a fee or a tax. Now CFDs, the county switched between a process where we normally establish a CSA for each subdivision to start forming CFDs, and that started around 2015 or so. We have two CFDs right now. The first one's for Santa Ana Ranch subdivision only, that's 2015-01. And there's a countywide community facilities district, 2018-01, that has, it was set up for 3 subdivisions, 2 of which have started to build. And also the new subdivisions that are formed in the future will annex in at a minimal cost to that countywide community facilities district. The facilities districts allow a better funding mechanism. So a CFD can fund both capital improvements and they can provide services. And unlike county service areas, which cannot provide a funding for a general governmental service, this is very critical. The CFDs can collect money for general governmental services, such as police, fire, district attorney, library, et cetera, that services that are provided countywide, and it actually is a significant amount of money per parcel. So, the first CFD, the Santa Ana Ranch, you notice that they have a $684 per parcel. And the new Brigantino one, there's Brigantino, Fay Bennett, and then the Bluffs were all part of this. The rate per parcels increased to like $1,500 for Brigantino and $1,700 for Bennett Ranch. I did not go back and relook at the budget numbers, but I believe that we're collecting about $751 per parcel just for governmental expenses, and the rest of that is project-specific expenses. So the county is collecting more money for general governmental services as well as the project development, costs in the CFDs. Not that it's important right now, but for fees, you cannot collect the money unless the service is generally available. Assessments and taxes you can collect for services that are going to be done in the future, but may not be available yet. For example, if you're maybe building a well or something. We've already talked about police power. I think we've already talked enough about preemption, and we've spoken about ordinances. I'd love to talk to you more about taxes and everything, but I think we'll do that a different day, about the different requirements to approve a general tax versus a special tax, et cetera. Does the board want me to go into more depth on any of those right now? Does that answer the question about CFAs and CFDs?
I think so.
Okay.
Perfectly stated.
Thank you.
Oh, and I just wanted to note that there was just a typo in the last presentation, 6th District Court of Appeals, just minor. Thank you very much, I appreciate it.
All right, so thank you. We're getting closer. So I got the last part here, so I'm going to go ahead and be brief with this. I wanted to go over a few things. I'm going to kind of break this up in a few sections. One is, I think it's important for your board members to understand, we obviously don't have a chair or a vice chair yet, so I think it's important for you to understand that there is we have a county, so if you're in your rules and procedures, PDF, if you look at the second page there under committees, it outlines that the chair shall appoint a committee at such times, and so on and so forth. So historically, what we have done is the chair actually appoints, and we have an example, I believe they're on your desk here, of the actual committees scheduled for 2020, okay? And there are different committees that may be part of. As an example, the second page here, we have, actually, we have the Monterey Bay Community Power at that particular time. That was what the name was. Now it's the 3CE, which is the Central Coast Community Energy. That's what it is. And so that name has changed. However, they have their own bylaws. They have their own regs when it comes to operating or being a part of that board. There's two of them. We have a policy board and an operations board. Board members will be, the board members that are here, they're, one of them will, actually there's two, there's a delegate and an alternate. And one of the board members will be regularly attending this particular meeting, which we have outlined in this matrix here of when you would be meeting. They have an operational board that also meets monthly. So the policy board meets, I believe, quarterly, and for the CAOs and the city managers within the, I believe it's now 5 counties, within those counties, the city jurisdictions, we all meet together, and we actually have a board meeting as well. So just wanted to let you know that your board, the chair, whoever the chair is, and actually I'd like to preface this as well. Staff has met, this is a very unique situation where we don't have a chair coming in and then handing off the chairmanship to a new chair. So what we decided to do is actually have the longest tenured board or supervisor open up the meeting, because we have to have a board member open the meeting up. So that'll be Supervisor Mark Medina. So he will open that up, open up the meeting, and then at that point, you guys will then move forward with picking a chair and a vice chair. But with that comes the responsibility. So whoever, and we don't know who the chair is going to be, whoever should be thinking about developing who's going to be on these committees, okay? And I just wanted to make sure you're all aware of it. So we have the committees here, and we have, if you open up the actual staff report, you'll notice there are a lot of attachments. I don't know if you noticed that. There are a lot of bylaws for all of those committees. We don't have them all, but we have a very good majority of them. We've also have a matrix that was developed that outlines most of the committees that we have, with a website that actually will link you to the content or the web page or the bylaws. And so we're still developing that, so there'll still be some changes and updates, but I wanted you to look to make sure that you are aware of that and that you understood where to go. We should, that's posted on our website, but it should be completed soon. So I just wanted to make sure. But most of it's populated. If you look at the second page there, there is actually a list of committees for each supervisor. So all you have to do is look at it at a glance. Okay, which committee am I going to be responsible for? And then we have the ad hoc committees that were discussed earlier today with Judith. We talked about the different types of committees. And so there are different ones here that we have, and they vary from year to year, depending on the situation, depending on something that comes up. So a good example is we're going to be discussing at the Tuesday board meeting the possibility of a round 2 of funding. We're going to review our budget with the CRF. We're going to review the $1 million, and we're going to discuss those programming and what was done this last year. And, with things, the way things are right now, things aren't looking good for some businesses. So there's an opportunity there for us to move forward to assist our community. So in that case, there can be an ad hoc created for that. So what we did this last year is we actually had a CARES Act Fund Committee, and then we had a Roadmap to Recovery Committee, as you see in the very back page there. So, in this case, we can create a COVID-19 Programming Committee, the 2 board members as an example, and go from there. So anyways, it's just an example. I wanted to make sure that you were aware of that, and I wanted to make sure that you're aware of the obligation based on the rules of procedure that our board members have to follow. Another at a glance is our County of San Benito local boards and commissions roles, responsibilities, and composition. This is a kind of a document to look at from a glance of what is it that this committee, what does it do? And I think it's important for you to understand, like when you are advocating or requesting someone, maybe a planning commissioner or whoever, to come in to do some work for you with, sitting in on the committee, it'd be good to have this information. So we want to make sure that it was available to you. If you had any questions, we would be more than willing to work with you on that. And it's a good at a glance, kind of really gives you kind of an idea of how many times, these committees meet and kind of what the responsibilities are of that committee. So I thought that was a good one. And then here's the matrix, as I mentioned before, which is attached. So that was, I think, what was really important for this Tuesday, for you to be aware of it.
Can I just kind of add for clarification
Sure.
that you addressed the error with my name being chair on the agenda?
Thank you, I will do that for the
I don't want anyone
record.
to think there was not anything improper. I had nothing to do with it, but it looks like we've already designated somebody. Yes.
So staff out of the clerk's office, in particular Jennifer, thought it'd be nice to have you as the chair. No, that's not true. Unfortunately, there's a certain part of the agenda that you have before us that we don't have access to, this county staff. And that is, if you look at the first page as an example, you have the names of all the supervisors. Normally, we have them install vice chair and chair, whoever that's going to be. So what happened is this year, we requested the change for the front page as well as the second page. We also requested that be done for all the other agenda items. Unfortunately, they didn't do that. So we requested it, hey, can you guys, this one wasn't done yet, so we asked them, but they forgot to remove the chair from you because Jaime de la Cruz
It was formerly
was District 3, and so
District 5.
District 5, my apologies, District 5, and so they left the chair there, so.
I saw it last night, I'm like, oh, wow, I've been promoted.
I actually asked Jennifer to send out an email notifying that it was an error,
But just
so.
for propriety's sake, I just don't want anyone to think that
Yeah, no,
we had decided on something unlawfully.
and that's good for the record to say that, so I appreciate that. With regards to conducting the meeting, I just wanted to share with you some of the documents that we have, the board meetings, and, we've been highlighting that already, so I think for the most part, you have all that information, as well as the rules of procedure. Going back to the board meetings, I just wanted to share with you that within this, we actually outlined how you can conduct the meeting, the third, fourth, and I think even fifth, maybe 6 pages there of what to say. So we've kind of already gone through that. I'll provide you, some, maybe the sixth page, if you go to the, almost second to last on that particular one, adjournment. I'm going to have one of your board members probably adjourn us, but it gives you what to say under adjournment, So that's just an example, where to go. We want to make sure that you were armed and ready to go. So whoever does become chair and vice chair understands what to do and how to conduct the board meeting. So we thought that was important. Going back to the rules of procedure, one of the things that was discussed were some possible changes. This is, let me see here, I think it's about 3 pages. And we actually have made some edits. I think it's about 19 pages, I think it is. We've been working on this. I think it's probably a good thing to come back to the board and at the board retreat to discuss some of those changes. I think some of it's more just being more aware of scheduling, what kind of a vote, what is a 4/5 vote? What type of items, as an example? Majority, a 3/5 vote, and having those. So just a little bit more detail when it comes to the actual procedures and what to follow. So we wanted to make sure that you guys are aware of that. So we're going to come back with a lot more detail, and then we can all talk about it. You guys can provide staff some direction on some of those items. So that's more or less it. I want to thank staff for coming in on a Saturday and all the great work that was done. There was a lot of preparation for today's meeting.
Thank you.
This is a first phased approach for education, oversight, and policy making. One of the things that we envision is to have a phase 2, and that phase 2 is going to come at the board retreat. And so we're going to talk about now education with regards to operations. What is happening with the budget, what's happening with our roads, our infrastructure, all of those things. So we want to educate you with our environment from an operation point of view. So we look forward to that. We've been working the last few months on developing agenda items for that as well. So there'll be a lot of work that'll be done or has been done already, but I think it'll be very educational. So with that, I appreciate everyone's time and your time. Yes, any public comment?
Members of the public who wish to speak, please press star 9 or the raise your hand icon. We have no speakers via Zoom at this time.
Okay. There was a quick request from, actually, I think it might be good just to quickly highlight. You want to quickly just highlight that, if you don't mind? It was brought up from our management analyst, Dulce Alonso. And this is regards to your responsibilities. This is going to be kind of key for the next board meeting when it comes to the financial corporation, so.
So I just wanted to let you know that as board members, you would be part of the Finance Corp. And the purpose of the Finance Corp is to assist the county with financial and transactions, remodeling, rehabilitation, facilities, land. So that those types of activities take place under the Finance Corp. On the next agenda, you'll meet under the Finance Corp and assign the members for the director roles, and then adjourn it. Yeah.
Thank you. So that, we wanted to make sure you're aware of that. And there's a lot of documentation in the, for those of you that have seen the agenda, what to do and what to say with that. But staff will be here to assist you. So yeah, with that being said, would Supervisor B. Gonzalez address the last item on our agenda?
Okay, so I'm acting as if I'm chair, of course. So do I have a motion to adjourn the meeting?
So moved.
Okay. So we'll then go ahead and adjourn the meeting with the meeting date of January 12th, 2021 for the next meeting.
Vote. You have to vote.
Oh, sorry. Call
All
for a
those in
vote.
favor, all those in
All those
favor?
in favor?
Aye.
Opposed? Okay, so 4-1.
4-0.
No.
Okay. So, motion adjourned? I mean, all right, so, meeting adjourned?
Thank
Okay.
you.
Good deal, meeting.
Thank you.
Thank you,
Good
everybody.
presentation.
And thank you for all the hard work you guys did. Wow.
Goodbye.